My lord, the land acquisition of
So whatever, sir, if before.
orders regarding limitation, orders matter regarding limitation.
লিখিদেবে পুরো অর্ডার লিখি
আগে yesterday আসলে ওটা 21 matter same না
সেটা ବି লিখি দিও
মুখ
yung sir mu diyo joda magchoti se likhi de
good.
memo de diyo
Supplemental list, page 1, 1 to 8.
My lord, item 2 after vacation.
ଆପଣଙ୍କ ନାଁ sir
PK Naik.
so PK Naik for the petitioner item 2 likhibe the matter having been listed for fresh admission is mentioned by the learned counsel for the petitioner seeking adjournment. The matter was heard at length on 22/1/2026. The facts as well as the legal issues were noted. Thereafter, the petitioner is consistent in seeking adjournment, of course, without any reason. On 17/3/2026 and 16/4/2026. To grant further opportunity to the petitioner, list in the week commencing, list for fresh admission in the 13/7/2026.
Item 3, man.
Yes.
There has been a person to order of this honorable court. I have filed the affidavit. But so far as the evidence is to scrutiny that I have
Which
not
order?
gone through.
Which
Item
order?
3, man.
Which order affidavit file for it?
Last statement of the last order.
Date of payment, mode of payment, region.
That affidavit I have filed. That is there, madam. But I pray for some time.
Denandi the region. Denandi.
This area, that is there, that noting.
Denandi. ପଢିବେନି ତ
ନା noting ଟା ଅଛି
କଣ ଲେଖିଛନ୍ତି ପଢି ନାହାନ୍ତି ତ ତ୍ରିପାଠୀ you don't ପଢନ୍ତୁ order ଟା ପଢନ୍ତୁ para 4
Petitioner shall also file affidavit indicating
କଣ ଚଷମା ପଡେ ଗଲା ଚଷମା ଆଣୁ ନାହାନ୍ତି you are straining your eyes
the details of payments made pursuant to the judgment of the Land and Family Court. That is date of payment, mode
Date of payment, mode of payment
by the
and the
next
next date. Judgment କେବେ ହେଲା 11/11/2021 ଆପଣ ଟିକେ affidavit ଟା ପଢନ୍ତୁ
ମୁଁ affidavit ଟା ଖାଲି overall ଲେଖି ଦେଇଛି
overall ଆଜ୍ଞା କିଏ କହିଲା ଆପଣଙ୍କୁ ଲେଖିବା ପାଇଁ it has to be rejected
ମୁଁ ଗୋଟେ fresh affidavit that affidavit I'll fresh
phrase ଦେବେ କି still ଦେବେ that is at your choice when the order is clear
not simple.
you are nobody to change the contents of the order and file another affidavit. That is how you lose respect from your client. Upon jodi tanku, if you don't settle your terms, se apanku ei kotha ସବୁ କରିବେ. Please appreciate that. ଆପଣ ଗୋଟେ ଭଲ ପଏଣ୍ଟ ନେଇଛନ୍ତି ଆମେ ପେମେଣ୍ଟ କରିଛୁ.
That I made.
So ସେଇଟା ଆପଣ ଲେଖିବେ.
That
ଲେଖିବେ ଆପଣ ଇଆଡୁ ଛଡୁ କାଇଁ ଲେଖିବେ?
No, I just overall have stated.
Overall କଣ? Overall କିଛି ଥାଏ ଆଜ୍ଞା?
ମୁଁ date wise ଲେଖିକି ଦେଇ ଦେବି.
Overall କିଛି ଥାଏ?
Not so give me liberty that I'll fill.
Unless you cover up.
Not so man.
Unless you cover up. The learned counsel, the matter being in the list for fresh admission is mentioned by the learned counsel for the petitioner seeking adjournment. He refers to the order dated 1/5/2026, paragraph 4, wherein the following was directed. Quote reproduce karte. He submits that the petitioner, with reference to the state order, in compliance of the state order at paragraph 4, has filed affidavit. Perusal of the affidavit indicates, though it runs to 3 paragraphs, but what was directed has not been mentioned. Apart from making statements that the amount has been paid. The order dated 1/5/2026 could not have been interpreted differently. Stop. To grant further opportunity to the petitioner, list in the week commencing. ଆପଣ 10 ଲକ୍ଷ କି 20 ଲକ୍ଷ ଦେଲେ that's not the issue.
Not so bad. That did understand.
That's a simple question.
Not so bad.
ଆଜ୍ଞା କେତେ ଟଙ୍କା ଦେଇଛନ୍ତି ବୁଝିପାରିଲେ ଆଉ ଗୋଟେ କ୍ୱେଶ୍ଚନ ହଉଛି ଆପଣ କେବେ ଦେଲେ କେତେ ଦେଲେ କେମିତି ଦେଲେ
Who mode ରେ ଦେଲେ that I will.
whatever କେବେ କେତେ କେମିତି ତିନିଟା କଥା
Liberty may be granted.
ଆପଣ ଖାଲି ଦେଲେ ମୁଁ ଏତେ ଦେଲି
Now, out of that 12,000.
You see that is how these cases are frustrated. ଆପଣ ପ୍ରଥମ ଦିନ ଇସ୍ୟୁ ନୋଟିସ୍ ହେବା କଥା ଆପଣ ଯୋଉ ଟଙ୍କା ଦେଇଛନ୍ତି କାହିଁ ନୋଟିସ୍ ହବାରେ କ'ଣ ଅଛି? You have a right legal remedy.
Liberty may be granted and file
ରିପୋର୍ଟ
fresh.
କ'ଣ ଦେବି ଆଜ୍ଞା? ରିପୋର୍ଟ ବାରମ୍ବାର ଦିଆ ହବ କି? ଆପଣ 4 ରେ ଗୋଟେ ଅର୍ଡର ହବ, 1/5 ରେ ତାପରେ ଆଉ ଗୋଟେ ଅର୍ଡର ହବ, ଆଜି ଗୋଟେ ଅର୍ଡର ହବ, ତାପରେ ଲିବର୍ଟି ବାଲା ଗୋଟେ ଅର୍ଡର ହବ, ସେମିତି କିଛି ନାହିଁ। ଆପଣ ଦେଲେ ଦେବେ ନ ଦେଲେ ନାହିଁ, ଆପଣ କ୍ଲାଏଣ୍ଟ ଲିବର୍ଟି କ'ଣ?
We commencing 13
Matter shall be listed for fresh admission in the week commencing 13/7/2024. Yes, please. Next.
That's it. Item 4. That's it. On behalf of Mr. Bikker Agada, I'm praying for adjournment.
Ms. P. Das learned for the petitioner. The first order tackle say order tackle. Date would change कर देवे 19/3/6/4/27/4. जो item 2 रे जो order था date केबे करंतु?
We commencing 13
Yes. Item 7 man. 7. Mr. BC Parija for the petitioner. The matter was listed on 10/4/2026. Today is again listed for fresh admission. The Lord Counsel for the petitioner mentions the matter seeking adjournment at the beginning of the day's proceeding. ସବୁ ଥିରେ is necessary to grant further opportunity to the petitioner. List in the week commencing
13
13/7/2024. Yes, next.
Phase 2
चलो 29/6 रे 88 6/7 रे 95 पहुंची गलानी. So that is how now he has to go to 13/7. कोन होती जे काहे की ने पोस्टिंग ही करी आउरी अछि 5-6 दिन तो कोर्ट हबो नियाती.
My lordship, item
Phase
9.
2 item 9 to 13
9.
Yes, sir. My lordship, seeking for an adjournment
You
to
are
take
Miss E रे आपण को नाटा?
S. Chimanka.
Yes, Miss S. Chimanka for the petitioner.
My lordship, seeking adjournment to take instructions.
The matter being in the list for fresh admission is mentioned by the learned counsel for the petitioner at the beginning of the day's proceeding, seeking adjournment. Stop. ଆପଣ ଏଥିରେ appear କରୁଛନ୍ତି?
My lord, item 13
ନାଇଁ ବସୁନ relax. The matter was had at length on 10/20/3/2024. The facts and legal issues were noted. Stop. Thereafter, the matter was adjourned on 4/3/2024 by the petitioner. To grant further opportunity to the petitioner. List in the week commencing. दियो दे
27
20/7/2024 13/7/71. Yes.
Pardon to mention, Your Honor, item 12 on behalf of Mr. Sheikh Ruplal. This matter may be.
Cannot be adjourned.
No, actually, what
Should have-
happened, the affidavit has been ready, but
It has to
the
be rejected.
BM is out of
the-
session.
Item 12 এটা କେତେବେଳେ ଆପଣ 2 PM ରେ ଅଛି, ଏଟା ମେନସନ ହେଇ ପାରିବନି,
No, out
ଆପଣ ତ
of
ପଢିବେନି ଆଉ.
what is it?
Say his presence will be procured.
Okay, 2
Court
PM.
knows how to procure the presence of the person. Be ready when he will be taken to court. କୁହନ୍ତୁ ଖବର
So
ଦିଅନ୍ତୁ.
he's out of station. The BM is out of station. That's
PM
the
କଣ?
instruction act I'm
PM
reading.
ମାନେ ଇଣ୍ଡିଆରେ ଅଛନ୍ତି ତ?
India.
This court exercises territorial jurisdiction in India. His presence will be procured. It is item 12 ଲେଖନ୍ତୁ. Sir, madam, it is very difficult to outwit a court. Court is not helpless and hapless, sitting and watching, looking at mercy of persons. So you disclose his details. Unless you disclose the details, it will not be adjourned. He is higher up, will be informed, and his presence will be procured.
At
You have to disclose the କୋଉଠି ଅଛନ୍ତି?
that instruction, I have not.
So don't belittle yourself. ଆପଣ ଜଣେ lawyer, ଆପଣ ଯେତେବେଳେ ଜଣେ client କହିବ ମୁଁ ବାହାରେ ଅଛି, ଆପଣ ପଚାରିବେ କୋଉଠି ଅଛନ୍ତି? ଲୋକାଲ ଅଫିସ ଆପଣଙ୍କର କିଏ ଅଛନ୍ତି?
Local visit, court, my lord.
The item 12 is mentioned by ଆପଣଙ୍କ ନାଁ ମ୍ୟାଡାମ
Rita Singh.
Ms. Rita Singh, learned counsel, who doesn't have power in the matter, seeking adjournment. On 8/5/2026, the following order was passed in presence of the learned counsel for the petitioner. Though the matter is specifically adjourned to be taken up at 2 p.m., it is mentioned by the learned counsel, Ms. Singh, though having no power, that she has been instructed by the learned counsel, Sri S.K. Ruplal, to seek adjournment on the ground of the branch manager, SBI General Insurance Company Limited, 191 Hon'Ble Nagar, Unit 3, Bhubaneswar, District Khurda, being out of station. The Director General Police shall instruct the Commissioner of Police, who in turn shall instruct the Deputy Commissioner of Police to ensure presence of the branch manager tomorrow at on 15th at 10:30 p.m. at 12:30. সকাল আনিବାକୁ অসুবিধা the পূর্ব লাইন লিখিবে on being asked লিখিবে as the submission is made that the branch manager is out of station, the learned counsel was requested to disclose his present location where he is traveling. In response, he submitted that she doesn't have any idea, as has not been instructed. তারপরে লিখিবে ডিজিপি কোনটো the constable name is DGP কোন the DCP DCP Bhubaneswar through the local inspector in charge and any staff of the police station shall ensure presence on 15 তারিখ লিখলে না আজ কি 12 না 13 on 15/5/2026 at 12:30 p.m. Copy of this order shall be handed over to the learned AGA. Item 10 টা 12 টা কা পাখরে থিব এক রু কা পাখরে আছে Mr. Prem Kumar Mahanti, who shall ensure compliance. The registry shall forward copy of this order to the DCP Bhubaneswar as well as inspector in charge, Hon'Ble Nagar Police Station, for compliance. Yes.
Page 3.
Madam, you were given a chance to file an affidavit. You do not file the affidavit in the name of the branch manager. Should I add to it? Order the court it is rather unusual that when the party is directed to file an affidavit, adjournment is sought for on the ground of the appellant being absent. Yes.
Madam, item number 16. I'm the virtual mobile.
The DCP shall verify the office records of the concerned branch regarding whether the appellant branch manager is on official authorized leave or not, and shall also furnish a report. Yes. Yes, please. Mr. Jana, then 48 more points. Just wait.
Lord, he is mentioning item 16. Mr. Jain.
No, 13, 9 to 13, how kya chunti? Mr. Jana, please unmute.
Item number 16, my lord. Mr. Praveen is there. That 5 matters have been listed. We commence from 30th July. Let this matter maybe the
Copy, sir. Copy, sir.
The annex.
copy of some.
16 lekho to Mr. Kishore Kumar Jana for the petition. Sri Praveen Das 16 re ki? Mr. Anshuman Sethi, additional standing counsel for the opposite party. Right, that could be if the branch manager appears on his own, the police did not enforce, the police did not intervene to ensure his presence. That could be that. The registry report, Mr. Kumar Janna for the petitioner, Mr. Anshuman Sethi for the R1 petition, no less appellate. Mr. S.K. Das, senior advocate, along with Mr. Praveen Das. Praveen Das, advocate for R2. Stop. It is submitted that similar matters have been posted to recommending
13-7.
13-7. Stop. The Learned Counsel for the Learned Counsel advocate on record for the opposite party requests for copy of the application along with annexes. Copy of the appeal memo along with annexes. How many copies, Mr. Das?
The annexures filed for delay and leave.
Kitna copy? Two
One
copies.
copy. One copy.
This shall be served with one extra copy of the appeal memo along with annexes and all the IAs.
Yes.
Within
Within 3 days?
3 working days to enable him to obtain instruction. The matter shall be listed in the week commencing 13/7/2024. Debe list list
That is LA 40/2024. This will come along
LAA 40 of 2025
2024
and the batch of case
40 of
and similar batch of appeals.
my lord
40 of 2025
24
Yes.
or 24
40 of 2024
40 of 2024
40 2024
40 of 2024 right. Yes.
17 years.
Yes. Adjournment.
My lord, Arjun.
CMA appeal adjournment.
My lord, seal. I have
Sanjeev Mahanti, Mr. Sanjeev Mahanti for the petitioner. The matter being listed for orders in the day's list is mentioned at the beginning of the proceeding, seeking adjournment to grant grant further opportunity to the petitioner. List in the week commencing. List for orders in the week commencing. 29/6/2026. Yes.
Page 4, 22, 28.
Item 20. On behalf of Suryagan Jana, paying for adjournment.
20.
Yes. Item 20. After vacation.
Sir?
Subhranshu Jana.
Mr. Subhranshu Jena on behalf item 20. Subhranshu Jena on behalf of Suryakanta Jena for the petitioner. The matter is listed for orders. But the matter was had at length on 10/4/2026. The facts as well as the legal issues were noted at were noted in some detail. The petitioner had adjournment to make further submissions to address further. Petitioner had adjournment to address further. Today, the matter being in the list for orders is mentioned at the beginning of the day's proceeding, seeking adjournment. Stop. To grant further opportunity to the petitioner, list for orders in the week commencing 27/2024.
23 wise. Item 23.
23, yes.
After vacation, instruction has not come.
23 posting कर दियो.
We commencing 20 sir.
32 minor of the same.
32 कर दियो.
27.
27.
And in fact, this case is covered by the judgment of this Hon'Ble Court in double PC number 25509 of 2022.
Correct, sir. You provide the cover to them. So that
Yes, madam, but
if
they have
cover themselves, no difficult.
they have filed counter affidavit.
No, cover you provide.
Yes, I am
The cover,
provided.
you inform them. cover sir देखो तू. If you act.
But against that judgment, writ appeal has been filed. Identical case.
Yes, sir. No difficulty, sir. But I cannot determine identity of case.
No, my lord,
They have to. They have to.
Yeah.
27. The matter is listed for hearing under the heading for admission. देखिए शरद चंद्र दास for the petition. 27 रे की रहेगा?
Ansuman.
So Ansuman Sethi for the adjunct standing counsel for the. Plural for the opposite party. Is submitted by the matter is listed for hearing under the heading for admission. It is submitted by the learned counsel for the petitioner that the issue involved in the writ application is already decided and covered by the decision of this court, single bench or division bench,
Single bench.
coordinate bench, dated
Dated 24th October 2025.
WC 10-20-25
In WPC number 25509
25509
of 2022.
of 2022. Copy of the said judgment na order said.
No, the judgment.
Copy of the said judgment is served on the learned additional standing counsel for the state to enable him to obtain instruction. Stop.
But again, that the
state for admission in the week commencing
27.
27 26.
writ appeal has been filed against this judgment.
ସେ କହିବେନି ଆପଣ ବି ତ କହୁଛନ୍ତି
Page 5.
perhaps what Mr. Das is saying that if it can be disposed of it will be covered by the writ appeal, or you can say maybe it would be let us wait for the writ appeal decision.
And in the counter affidavit file, they have not given any reference of this case.
Counter दरकार
Aye.
basic law pleadings is that
The
one
other
should
way,
not
it
plead
can be-
questions of law.
In the other way, it can be disposed of subject to outcome of the
ଆପଣ
writ
instruction
appeal.
ନିଅନ୍ତୁ ସେଇଠି instruction ଟା ସେଇ ଇନଫ୍ୟାକ୍ଟ ସେଇଥିପାଇଁ ମୁଁ ଆପଣଙ୍କୁ କହୁଛି ଯଦି ଆପଣ କହିବେ dispose of ହେଇଯାଉ ତାହେଲେ
Subject to outcome
but-
of the writ appeal.
but don't do it without instruction.
No, I'll take it.
Yeah. So that unnecessary ତାପରେ ସେଠୁ ଜିନିଷଟା ଝୁଲିକି ରହିବ. Page 529 to 33.
Lordship, on behalf of Advocate Satyaprakash Satpathy, Lordship. Item 33, Lordship. Seeking an adjournment on behalf of
33 Satyanarayana
Satyaprakash Satpathy, second name.
Satyaprakash. SN Mahapatra. Other side,
We have taken consent from you. Listen.
ସେଟା ସେ ଆସିଲେ କାଲି Mr. Sajan was present after in the second bench. Special bench ଆଜି ବି ଅଛି ସେ 4ଟା ବେଳକୁ ଆସିଲେ ମାନେ 3:30
We
ବେଳକୁ
have
ଆସିଲେ
taken the sir's answer.
ତାହେଲେ ଠିକ ଅଛି ଡେଟ୍ କରିଦିଅ ସେ କିଛି ଡେଟ୍ କହିଲେ
Date is not consent date.
ସେ ଗୋଟେ କାଲି ମେନସନ କରୁଥିଲେ ଯେ ଅର୍ଜେଣ୍ଟ ନିଅନ୍ତୁ ବୋଲି just take it up around 4:30
We counsel 27.
we commencing 27 34 ରୁ 41
40 item number 40 man.
35
I don't know, 36, man.
is 36 କୁହନ୍ତୁ sir
TRP 183 and 165. I am appealing for the petition. Mr. Raut is appearing for the opposite party. I have taken consent.
sir ରାଉତ ଅଛନ୍ତି ତ
Achha.
ଡେଟ୍ କେବେ କୁହନ୍ତୁ
After vacation.
ରାଉତ କହିବେ ଆପଣ
ନା,
ଆପଣ
yes.
ଆସନମେଣ୍ଟ ସେ ଡେଟ୍
Yes, yes, my lord.
ଏନି ଡେଟ୍ ଦେଖନ୍ତୁ
We counsel 27.
27
39,
Obliged.
application on behalf of the Out.
39 Mr. Mahapatra
39 on behalf of the Out. I am a scanner.
39 state adjournment ଚାହୁଁଛନ୍ତି
ପ୍ରଭୁ ଦର୍ଶନ
ନାଇଁ ମୁଁ ପାର୍ଟି ମେନସନ କରୁନି କିଛି ସିମ୍ପଲି କମ୍ପ୍ୟୁଟରରେ କରିଦଉଛି so that order will be reduced 39 ଟା ପୋଷ୍ଟିଂ କର
We counsel 27.
Item 41.
Item 40.
40 ଆପଣ ମେନସନ କରିଥିଲେ ନା
40
ଆପଣ ସରି
after vacation of mine. Counter already filed.
ବିଦ୍ୟାଭୂଷଣ ଅଛନ୍ତି ତାଙ୍କୁ ଅଦର ସାଇଡ୍ ପିଟିସନରଙ୍କ ଆବସେନ୍ସ ରେ କରନ୍ତୁ ତାଙ୍କୁ ଆଟଲିଷ୍ଟ give him the confidence. ଯଦି ସେ agree ନ କରନ୍ତି he may come up, please be present.
ମୁଁ କହିବି
ସେ କିଛି କୁହନ୍ତି I can adjourn, no difficulty, but please inform them. 40 ଟା କରନ୍ତୁ ଡେଟ୍ ଆଜ୍ଞା।
We commencing 20 sir.
20 ସାର୍ ଆପଣ 41 କହିଲେ ନା?
Yes, my lord.
Yes.
Item 41, I pray for after vacation.
ଆପଣ ଅଦର ସେଟ୍ ପାଇଁ
Sir, on behalf of Sanjay Kumar Das for petitioner.
Here, my lord.
ଗୋଟାକରେ ଆପଣ ପିଟିସନର ଆଉ ଗୋଟାରେ ସିଏ ହଉଛନ୍ତି
Aye.
କେବେ ଡେଟ୍ କରନ୍ତୁ 41
We commencing 20 sir.
20 ସାର୍
Interim order was there.
Procedural stay or adjournment?
Stay was there.
Stay I am not touching. I am not
Adjourn-
passing any order. Adjournment जो थी वो କରିବାକୁ ପଡିବ।
Adjourn, I think, I don't know. Also, I'm
ଦେଖିଦିଅ। It is a adjournment order. Okay.
yes.
41 ଲେଖନ୍ତୁ ଆପଣଙ୍କ ନାଁ ମ୍ୟାଡାମ
Priyadarshini Mahapatra.
ମିସ୍ ପ୍ରିୟଦର୍ଶୀ TRPC 12 ରେ ସେ ଦିଦି ଯା ଗୋଟେ ଅର୍ଡର କରିଦେଲେ ମିଶେଇ କରିଦେଲେ TRPC 12 of 2026 ମିସ୍ Priyadarshini Mahapatra on behalf of SK Das for the petitioner, Mr. R. Mahato on behalf of Arijit Mishra for the opposite party. TRPC 323, Mr. R. Mahato for the petitioner, Ms. Priyadarshini on behalf of Sanjay Kumar Das, SK Das for the opposite party. The matter is listed for hearing under the heading for admission. Stop. The Lord Counsel for the parties mentioned the matter at the beginning of the day's proceeding, seeking adjournment. The matter shall be listed for admission in the week commencing 27/24. Accordingly, it is directed the Lord Judge Family Court, Kendrapada, shall adjourn the CP number 140 of 204 to a date as would be suitable to the Lord Court in season beyond 27/24. 27/24 upon a prayer being made for the said purpose.
Bless her.
item 34
34
I am for the opposite party.
ଟିକେ ତାଙ୍କ ପିଟିସନର କୁ କୁହନ୍ତୁ ଏଥିରେ ଆପଣଙ୍କର ପ୍ରୋସିଡିଂ ଟା ଷ୍ଟେ ଥିବ ନା
Stay ଅଛି sorry ଜାଣିନି ଏଥିରେ କଣ ହେଇଛି
ଆପଣ ତାଙ୍କୁ ଇନଫର୍ମ କରି
Mr. Paningrahi was engaged as a counsel for the opposite party. He is no more.
ତ ଚାଲିଗଲେ ବଟ୍ ଆପଣ ଯେତେବେଳେ ଅଛନ୍ତି
File ଟା
ଅଦର ସାଇଡ୍ କରି ଜଣାନ୍ତୁ
ଫାଇଲ ଟା ତାଙ୍କ ପାଖରେ ଅଛି
he
ମୋ
passed away
ପାଖରେ
suddenly on it ମାନେ
ଫାଇଲ is not with me.
unexpectedly passed away
Kindly
ଠିକ ଅଛି ତାଙ୍କୁ ଜଣାନ୍ତୁ ଜଣେଇଦେବେ
ପ୍ରଶାନ୍ତ କୁମାର ସାହୁ
କିଏ
କିଏ ଜାଣିବ
ଆସନ୍ତି ତ ଆସିପାରନ୍ତି 34 ଟାକୁ ଡେଟ୍ କରିଦିଅ ଆପଣ ଯଦି ନମ୍ବର ନେବାକୁ ଚାହୁଁଛନ୍ତି ସେଇ ଯୋଉ ପେପରଲେସ୍ କୁ ଯିବେ
ସ୍ମେଲ
ଓକିଲାତନାମା ଟଚ୍ କରିବେ ସେଠୁ ପାଇଯିବେ ଏଭ୍ରିଥିଙ୍ଗ ଇଜ ଆଭେଲେବଲ ସାର୍
We commencing 20 sir.
କଲ୍ କରିଦିଅ ନା
Item 1,
ଯୋଉଗୁଡାକ ମିଷ୍ଟର ପାଣିରେ ଆପିୟର କରୁଥିଲେ ସବୁଗୁଡାକ ଆପଣଙ୍କ ପାଖରେ ଅଛି ବ୍ରିଫ୍
ନାଇଁ ସବୁଗୁଡା ନାହିଁ କେତେ ଗୁଡା ମୋ ପାୱାର ଅଛି
ସେଟା ତାଙ୍କର ମେମୋରିକା ଫାଇଲ କରି ତାକୁ ଇଏ କରିଦିଅ ରେଗୁଲାରାଇଜ କର
May I please also?
तो एक ही बेहरा for the petitioner.
My lord. Present petition is the father-in-law of opposite party 2, my lord.
Yes.
Challenging the order passed by the family court Noyagada in CPCase 116 of 2018, awarding maintenance of 3,000 and 1,500 for opposite party 1 and 2.
125.
Yes.
125.
Filed
So
by
the husband and the father has passed away.
No. Opposite party 2's husband, wife, petition is the father-in-law of opposite party 2.
Sit में पहुंचा देता strange. I was not expecting that.
The poor mortgage. Present petition is the father. The poor mortgage.
ମୁଁ କହିଲି ତ ସେ
ଆଜ୍ଞା
ଆଉ ସେ ହେବେନି ହଜବେଣ୍ଡ ହେବେନି ତାଙ୍କ ବୋହୂଙ୍କର
ଆଜ୍ଞା
ଆପଣ କହୁଛନ୍ତି ଫାଦର ଇନ୍ ଲ କର ଏଗେନ୍ଷ୍ଟ ରେ ବିନୋଦିନୀ ମାଝୀ ଫାଇଲ କଲେ।
ୟେସ୍
ଫାଦର ଇନ୍ ଲଙ୍କର ଯିଏ ଆପଣଙ୍କର ସନ୍ତୋଷ କୁମାର ମାଝୀ ହଉଛନ୍ତି ତାଙ୍କ ପୁଅ ନା ନାଇଁ?
ପୁଅ ପୁଅ
ଆପଣ କୋଉ ମନା କରୁଛନ୍ତି?
ହଁ right. So present present
ଆଉ ଝିଅ ଛୋଟ ଛୁଆଟା ତାଙ୍କ ନାତୁଣୀ
ନାତୁଣୀ
ଆଉ ମୁଁ ଠିକ ବୁଝିଛି ତ?
ଆଜ୍ଞା
ଆପଣ କଣ
ହଁ,
ଆପଣ
ଠିକ।
ଯେମିତି ହବା କଥା ନୁହଁ?
ଆଜ୍ଞା
ଆରେ ୟୁ ଆର୍ ଅଲୱେଜ ୱେଲ୍ ପ୍ରିପେୟାର୍ଡ ଅନଏକ୍ସପେକ୍ଟେଡ ଦ୍ୟାଟ୍ ଆପଣ ଫ୍ୟାକ୍ଟରେ ୟୁ ଆର୍ ଅଲୱେଜ ୱେଲ୍ ପ୍ରିପେୟାର୍ଡ ଆଇ ଫାଇଣ୍ଡ ୟୁ ବଟ୍ ଏଥିରେ ମୁଁ ଆପଣ ଯେତେବେଳେ କହିଲି ଯେ ଦ୍ୟାଟ୍ ଦ ପର୍ସନ ଆପଣ ଯୋଉ ଫାଦର ଇନ୍ ଲ କହୁଛନ୍ତି ସୋ ତାଙ୍କର ବୋହୂ ଆଉ ତାଙ୍କ ନାତୁଣୀ ଫାଇଲ କଲେ
ଆଜ୍ଞା
ସୋ obviously ତାଙ୍କ his son has passed away.
ଆଜ୍ଞା so my humble submission my lord.
ଏଇଟା ତ ପୁରୁଣା କେସଟା,
ଆଜ୍ଞା
ଏଇଟା ବହୁତ ପୁରୁଣା କେସ
ଆଜ୍ଞା
because this story is କିଛି ଭୁଲ ନାହିଁ ଏ ଅର୍ଡରରେ।
order बोलना है କିନ୍ତୁ ये father ना aged about 64 years
60 or
so he had
94
no independent income source
125 ରେ ଆଜ୍ଞା 64 94 କିଛି ନାହିଁ।
independent
ତାକୁ
income
କହିବା
source
କଥା
ଆଜ୍ଞା
ଯେ whether he is
agriculture income source of
whatever ଆପଣ ଏଗ୍ରିକଲଚର ଇନକମ ରେ ସେ କଣ ମାନେ
she is also a working lady my lord
ସେ ୱାର୍କିଂ ହୁଅନ୍ତୁ ଅନୱାର୍କିଂ ହୁଅନ୍ତୁ they
Working
can't be ଆପଣ କ୍ଲେମ କରୁନାହାନ୍ତି
ଆଜ୍ଞା
125 ରେ ଆପଣ କ୍ଲେମ କରନ୍ତୁ।
I have other two sons
So ଆପଣ କୋଉଠୁ ଆଣିକି ଦେବେ that's not the issue. So you being the head of the family they can't be driven to destitution and vagrancy.
she has also
ସେଟା ଆପଣ ପ୍ରୁଭ କରିବେ ସାର୍।
ଆଜ୍ଞା
ଏଇଟା ଗୋଟେ ଡିବେଟ କମ୍ପିଟିସନ ହଉନି ବୁଝିପାରୁଛନ୍ତି?
ଆଜ୍ଞା।
ଭଲ ଡିବେଟ ହେଲା ଜଣେ ପଦକ ନେଇକି ଗଲା ଇଟ୍ସ ଏ ମ୍ୟାଟର ଅଫ ପ୍ଲିଡିଂ ଆଣ୍ଡ ପ୍ରୁଫ you must understand that. More suppose I also think that 64 years of age, what can I do about him? I have all sympathy. Even I know personally that that person cannot earn. This order is perfectly reasoned. After death of the husband and the father, if the daughter-in-law and the granddaughter is neglected or they can't be driven to, then what is the purpose of this act 125 or domestic violence?
I think my humble prayer my lord notice will go there are chances of compromise
Maintenance रे compromise करी होगा.
there is chances so one chance may
There is no
requirement
rather it is against law. ଆପଣ ଯଦି compromise କରିବା ପାଇଁ ଚାହୁଁଛନ୍ତି ପଇସାଟା deposit କରନ୍ତୁ notice ନିଅନ୍ତୁ ଯାହା କରନ୍ତୁ.
so that's a good chance require
Chance not taking notice. I have already decided. Read C Lalita also. The parties cannot be driven to litigation. They are already destitute and their finding is there in their favor. You see, look at what the revisional court is doing. Revisional court cannot take a different view. Compromise regarding money cannot be done by this court. Compromise upon mediation koutre hochi relationship. Court cannot grant any money. You cannot give any money.
out of court
That's a different thing. But court by issuance of notice he can't be they can't be driven to litigation, invited for litigation. And I have already decided in one matter. Mr. Ratha argued that. Order 47, Rule 10 and 11. Same principle. ସେଥିପାଇଁ ଆପଣଙ୍କର in 2001 जो amendment ହେଲା 41 47 no 41 ବୋଧେ order 40 appeal sorry XLI ସେ जो रोमान ଟା ମନେ ରଖିଲେ confusion ହେଇଯାଏ. I try to remember the Roman. So 41 ଆପଣ ଦେଖିବେ 10 Order 41 Rule 10 appellate court may require appellant to furnish security for costs. Order 41 Rule 11
again
power to dismiss appeal without sending notice to the lower court. The appellate court after fixing a day of hearing for the appellant or his pleader and hearing him accordingly, if he appears on that day, may dismiss the appeal. सेटा आगुरु थिला एक साथ 2002 amendment आसला major amendment. The appellate court, after sending for the record has been omitted also. And now the difficult part. Appeal is a wider jurisdiction. Revision is a much, compared to appeal, is a less wide jurisdiction. So those principles have to be followed. Then in that C. Lolita judgment, Supreme Court has said that parties cannot be dragged to litigation. Because you are a judgment debtor and you see the amount is very less. सी भी केते टंका कहउचंती केते टंका देबे सी ताको भाई देबे तांकर अन्य पुओ माने देबे कि कोट आनिबे कोन करिवे you see then the whole situation collapses. The court cannot be a party to it.
Right. Yeah, practical jinso she is residing at their parental house now. So
parental house रे रहिले भाई बनी बनी जदी सुनंदो आपनकर कोन होची कहले एटा बहुत थोड़ा एक्सप्लेन करले. What is the difference between your speech and the common man's speech?
There is
that
difference.
you speak, talk, read, understand law.
Yes, ma'am.
You're always whatever deliberation you are making. It's not a speech actually. It's a deliberation. It is a speech, of course. They cannot deliberate. See, I am both osvidar achi. Upon both osvidar ki provision dekhchan.
No.
See, question aega see the takar provision mu kai debi. There are good provision rahwa darkar.
Yes.
Tal kohe mu kon karibi. These are very apt expressions as far as common discussion is concerned, common sense, common logic. But is it legally sustainable or tenable? Or does it have a legal flavor? The answer is very clear. It doesn't have any. So there lies the struggle for the court as well as the lawyer. That is how you have to assist me. Suppose there is a point in that a osvidar achi tang ghare rochoti. If you search for that provision or case law, then the court can do something. If you see the series of Supreme Court decisions,
Allahabad High Court.
Allahabad High Court doesn't follow Supreme Court. How the High Court, this court is bound by Supreme Court. As such, it is not bound by Allahabad High Court.
If you working lady
also
she is not.
It is completely in contrary to Rajneesh versus Neha.
Rajneesh Neha sir, if jodi se survey father-in-law
Rajneesh Neha, one chapter is regarding the potential to earn, capacity to earn. Everything has been discussed.
Allahabad
High Court has, if has not forayed Rajneesh versus Neha or interpreted Rajneesh versus Neha, that's a different thing. But I cannot ignore. Not only Rajneesh, it is Odisha High Court decision. Rajneesh has followed so many decisions. And followed for date of payment from the date of application, Supreme Court has followed 2 Odisha High Court decisions. And the potential to earn and the wife's capacity to earn, and they have also discussed maybe Delhi and other high courts. It is almost, it is a, it has, our subsequent decision, the Purbo decision bhi achi. Capacity to earn for a wife deprives of or disentitles her for, this cannot be the judgment of Allahabad High Court also. If it is, then it has to be tested. Because when suppose this court has a full bench decision, assume larger bench, full bench, 3 judge, or full bench 5 judge, which is contrary to Supreme Court decision, then what is the law? Is it binding on the single bench? The problem is the single bench then has to say that yes, Supreme Court is not binding, larger bench is binding. The law is that Supreme Court is binding. 141, 142. Do you find any provision in for High Court decisions? Article 141. Article 141 कौन कहले? Thank you. Law declared by Supreme Court to be binding on all courts. The law declared by the Supreme Court shall be binding on all courts within the territory of India. So this has been interpreted in several cases. How a High Court will differ? It has to defer. It has to be treated with deference. Can't be deferred.
Where there is a specific mention, my lord, that the law is kept open. In that case, High Court is entered.
Sir, obiter dicta, correct. We are not observing anything on the portion of law, as Mr. Lenka is saying, then High Court can. But the principle is even obiter dicta of Supreme Court is binding. Many a times you will find actually the question of law raised in the application is answered. Apart from that, another comment is made or another proposition is laid by the Supreme Court. Obiter dicta. That is not ratio decidendi. Still, obiter is also binding on Supreme Court, on High Court. Now, Mr. Lekha, you just read this. This is something else. Not agency. Did you refer to Bowstead and agency? This is something else. Just for general interest. Yesterday it was cited actually. Ms. Das cited. So that is how I came to know. You have to work on this, Mr. You have a responsibility, bigger responsibility. You have to tell them.
Yes, yes, I will.
Because this 15 at 125.3 has been interpreted by Justice Krishna Iyer. That is the decision relied on by Justice versus Neha. So, see, 125.3 is a very old. ଆପଣଙ୍କ CRPC କେବେଠୁ ହେଲାଣି 1973 ମସିହା ତା ପୂର୍ବରୁ ଆଉ ଥିଲା
7.
The learned counsel for the petitioner is had at length. The petitioner before this court is the father-in-law of the OP number 1 and grandfather of the OP number 2. Unfortunately, the son of the petitioner has passed away, leaving the opposite parties 1 and 2 as the legal heirs. So, did you go through the order of this court?
Yes.
Achha, yes. Yes. But there are some typographical mistakes in the order of the Honorable Apex Court. Say, CB Amabadiya under pressure. After death of the son of the petitioner, the OP1 wife, surviving wife, and the OP2 minor daughter represented through her mother filed petition on the Annex 2 ta 125 na section 19 application. तो बेरा
आगे
नहीं don't get confused. हमारा भूल भाल लिखा है तो सीधा ऑप्शन एंड मेंटेनेंस एक्ट पिटिशन टा देखले आपण Annex 2 देखो
Annex 2 the petition under section 19 of Hindu Marriage Act maintenance.
आपण को पड़े गले कंप्यूटर सिस्टम कोड ते आपण देखना देख आपण दुसु ची मुजेडा खोली ची देखना देखो लिखा है copy of the application under section 125 CRPC. कौन होची कौन लिखी so से अनुसार मु 125 डिक्टेट करे आरंभ कर दी कौन लिखी
Copy of application under section 19 of Hindu.
कोन पेपरलेस रे बुक मार्किंग करिसंती 125 मोर इंडेक्स होची पेपरलेस रे बुक मार्क ताको लिख देछन 125 CRPC मु सित पय भाबिली 125 CRPC कोन हां देख सो हां Section 19 of the Hindu Adoption and Maintenance Act, 1956, providing for maintenance of widowed daughter in law. Comma, before the Learned Judge Family, before the Learned Family Court, Noyagad. CP नाटा देखली फाइल CP नंबर 116 of 2018. The application was favored. On Annex 2 देखो bookmark लिखले copy of the application under section 125 of CRPC. Petition ta section 19 of the Hindu Adoption and Maintenance. एवढा कौन सी सिखातु लेखिकी रखंतु जे कोचोंदी से जानि नाहंती बट सेटा कोन सबुळे सिंती चलिवो. Only application was favored. Directing the present petitioner, opposite present petitioner, defendant to pay rupees 3,000 to the daughter-in-law and rupees 15,000 to the grandchild.
1,500 man.
1,500. 3,500. 3,500. Wow. The issues raised in the petition before the Lord Judge Family Court as well as this revision was deliberated in court. It is submitted by the Learned Counsel for the petitioner that there is a possibility of the parties arriving at an amicable settlement acceptable to all. The matter may be adjourned. So, the Learned Counsel for the petitioner is apprised of the judgments of the Honorable Apex Court, wherein the maintenance granted to daughter-in-law and minor child have been dealt with. The nature of such grant and the constitutional philosophy behind enactment of Hindu Adoption and Maintenance Act, 1956, particularly section 19. Stop. Matter shall be listed for fresh admission in the week commencing
on 3
Mr. Bera.
First week of July.
First week, right? 6-7. Commencing 6-7 20-26. अरे आपण देखिबे आपण कहते इंडेक्स टा भूल गला बोली. Copy of the application under section 19 पूरा लिखियो देखि जो पेज ना. It's always better to see and write. Well, भूल section 23. Sorry, I'm sorry, movie भूल गई. Page 23 annex 2. ଆପଣ ତ କେମିତି କର ତାପରେ ଆଉଥରେ ଏଡିଟ୍ କରି ଏଡିଟ୍ ମାର୍କ ନା କଣ ମାର୍କ ଆପଣ ଆଉଥରେ ଏଡିଟ୍ କରି ସେଇଦିନ ଯୋଉ ଅର୍ଡର ହେଲା ଆପଣ ଏଡିଟ୍ କରି ଦେଇଥା. ସେ ଆଉ ଦସ୍ତଖତ କରିବା ଦରକାର ନାହିଁ. ଆପଣ ତ ଥରେ କରିଛନ୍ତି ଆଉ ସେଟା ବାଇ ମିଷ୍ଟେକ୍ ସେଟା ରହିଯାଇଛି ଆଉ. Yes, next please. Call.
Item C, 5.
So Priyaranjan Singh for the petitioner.
The petitioner is the wife. Opposite party 1 is the husband and 2 is the mother-in-law. Their marriage was preliminarized, my lord.
The petitioner has married state.
My lord.
You are saying opposite party number 1 is the
Sorry, my lord. Opposite party number 2, my lord. I am sorry.
thought that
I am sorry, my lord.
କିନ୍ତୁ ସାହାଡା ଗଛକୁ ବାହାଘର କରନ୍ତି
No, no, my lord,
ହେଇପାରିବ
I'm sorry.
ହେଇଗଲା ସେଟାକୁ ଆପଣ ଇଏ ହେଇଗଲା ଆଉ ଦଶଖତ ଦରକାର ନାହିଁ ଆପଣ କରିଛନ୍ତି ଦଶଖତ ସବୁ କଥା ହେଇଛି କିନ୍ତୁ କରେକ୍ସନ ଟା ଛାଡି ଦେଇଛି yes
My lord, the petitioner is the wife and OP number 2 is the husband and OP number 3 is the mother-in-law. Their marriage was preliminary in the village, my lord.
ମଦର ଆପଣ ନାଁରେ ଡୋମେଷ୍ଟିକ ଭାଇଲେନ୍ସ ଫାଇଲ କରିଛନ୍ତି
ଏଇଟା ମୁଁ ଆଜ୍ଞା ଟ୍ରାନ୍ସଫର ପିଟିସନ ଟା ଦେଇଛି ଯେହେତୁ ବୋଥ ଆର ବିଲଙ୍ଗସ୍ ଟୁ ଢେଙ୍କାନାଳ କନଭିନିୟନ୍ସ ପାର୍ଟି।
ଡୋମେଷ୍ଟିକ ଭାଇଲେନ୍ସ ମଦର ଇନ୍ ଲ ଫାଇଲ କରିଛନ୍ତି ଆପଣଙ୍କ ନାଁରେ
ନାଇଁ 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 ମୁଁ ଆଜ୍ଞା 498 କେସଟା ଫାଇଲ କରିଥିଲି ତାଙ୍କ ନାଁରେ ଯେତେବେଳେ ଭଡାରେ ଆମେ ଭୁବନେଶ୍ୱରରେ ରହୁଥିଲୁ ତେଣୁ ସେଇଥିପାଇଁ ମୁଁ ଟ୍ରାନ୍ସଫର ପିଟିସନ ଟା ଭୁବନେଶ୍ୱରରୁ ଢେଙ୍କାନାଳ ମାଗୁଛି ବର୍ତ୍ତମାନ
498 ଏଇଟା
ଆଜ୍ଞା
ଆପଣ ନିଜେ ଫାଇଲ କଲେ ନିଜେ ଆପଣ ଟ୍ରାନ୍ସଫର ଚାହୁଁଛନ୍ତି
କନଭିନିୟନ୍ସ ଅଫ ଦି ପାର୍ଟି ବିକଜ ଅଲ୍ ଆର୍ ବିଲଙ୍ଗସ୍ ଟୁ ଢେଙ୍କାନାଳ ମିଲର।
ଆପଣ ମିଶି ଯାଉନାହାନ୍ତି ଝଗଡା କାହିଁ କରୁଛନ୍ତି ଆପଣ ଯଦି ବର୍ତ୍ତମାନ ମାନେ ଅଦାଲତରେ ଆପଣଙ୍କର ଅଦର ସାଇଡ ପାଇଁ ଏତେ କନସର୍ନ
ଅଦର ସାଇଡ କନସର୍ନ ନାହିଁ
ଦିଅନ୍ତୁ 498
ବିକଜ ମିଲର ଦେयर ଇଜ ଡିଫିକଲ୍ଟ
ଆପଣଙ୍କର ଅଦର ସାଇଡ କୁ ସୁବିଧା ହେବ ବୋଲି ଏଟା କରିଛନ୍ତି ଏହା କହୁଛନ୍ତି ନା
Convenience
ଅଫ ଦ ପାର୍ଟିଜ
ବୋଥ ପାର୍ଟି ଯୋଉ କନଭିନିୟନ୍ସ ଅଫ ଦି ବୋଥ ପାର୍ଟିଜ ମିଲର
କୋଉଠି ଆସିଲେ କୋର୍ଟ କୁ ଜଏଣ୍ଟ ପିଟିସନ ଫାଇଲ କରିଛନ୍ତି
ନାଇଁ ନାଇଁ
ମୁଁ କେମିତି ଜାଣିବି
that is the law is there ମିଲର ଲର୍ଡସିପ କାଇଣ୍ଡଲି ସି
ଲ ଅଛି ଯେ କୋର୍ଟ ଜାଣିଯିବେ ଜଣେ ଆସିଲେ ଆର ସାଇଡ ର କନଭିନିୟନ୍ସ
କନଭିନିୟନ୍ସ ଲେଖା ହେଇଛି ୱାର୍ଡ ଆଜ୍ଞା 407 ଇଫ କନଭିନିୟନ୍ସ ଅଫ ଦି ପାର୍ଟିଜ ମିଲର
ହଁ ଯେ ଆପଣ ଫାଇଲ କରିଛନ୍ତି କହୁଛନ୍ତି ନା
ଫାଇଲ
ଆପଣ ବୁଝିପାରୁନାହାନ୍ତି ତାହେଲେ 407 କହିଲା
ମୁଁ ଗ୍ରାଉଣ୍ଡ ଟା ଆଜ୍ଞା କହୁଛି ଫାଇଲ ଟା ସେ ଫାଇଲ
ଦେଖନ୍ତୁ 407 କହିଲା ଇନ୍ ବାଇ ଏନି ଅଫ ଦ ପାର୍ଟିଜ
ମାଇଲର
ଆପଣ କହୁଛନ୍ତି ବୋଥ ଦ ପାର୍ଟିଜ ୱାଣ୍ଟ ଇଟ ସୁଡ ବି ଢେଙ୍କାନାଳ ସେଟା ମୁଁ ହାଉ ଦ କୋର୍ଟ ୱିଲ ପ୍ରିଜ୍ୟୁମ
ବୋଥ ପାର୍ଟି ଷ୍ଟେଇଂ ଆଟ୍ ଢେଙ୍କାନାଳ ଆଇ ଏମ୍ ସେ
ଆରେ ସେଟା ଆପଣ ଢେଙ୍କାନାଳ କଲେନି କାହିଁକି
because at that time
you are the complainant you lodged an FIR
my lord
now you say that since the accused are staying in Deccan it should be transported to Deccan
no accused are not staying but
where is the cause of action occurred where the cause of action
both are there my lord in a 498 case my lord marriage was Dhenkanal staying in the matrimonial
marriage re habani cause of action
in 490 case haba aigya
dekhile
ai lordship kindly see my lord the
498
it is a continuing offense lordship the
who decision is 498 re haba
aigya in the case of my lord the Hon'Ble Supreme Court
अरे 498 रे आपण cause of action कोठी अछि सेडा सुप्रीम कोर्ट डिसीजन
सेडा सुप्रीम कोर्ट डिसाइड कला the wife who are residing after my lord the marriage my lord lordship the judgment of the Rupali Devi versus state of Uttar Pradesh
पारा पढु
para my lord para 16 my lord we therefore hold that the court at the place where the wife takes shelter after leaving or driven away from the matrimonial home on account of act of cruelty committed by the husband or his relatives would depend on the factual situation. Also, the jurisdiction to entertain a complaint alleging commission of offence under section 498.
That is directly against you.
My lord,
it is directly against you. You have already lodged a complaint here. छोड़ डाउट रे पढंतु.
एटा प्लेस टा दे जगह एई
आपण तो प्लेस टा दे जा ओडिया रे कोन लेक्चर इंग्लिश रे लेक्चर दी. छोड़ डाउट रे पढु नांती. ताकू पढंतु. मते कोन मनउचंती. आपण से पैराग्राफ टा आउथरे पढंतु. म्यूटेड हे गेला. Upon you are citing a decision directly against you. You have filed a so 16 says where you stay. You have already filed that as per 16.
Not after my lord, they are at that time they are staying at in a rented house.
Exactly. So that put upon wherever she goes, it will be filed. The decision is directly against you.
No, it is a decision, my lord, where the complaint.
It is a decision. Short out there, पढ़न्तु. ଆପଣ ଆଜି କେସ୍ ରେ ପଢି ହାରି ଯାଉନାହାନ୍ତି ବ୍ୟସ୍ତ କାହିଁ ହଉଛନ୍ତି
let's see any other day any other day I am satisfied
ଆରେ ପଢୁନାହାନ୍ତି ଷୋଳଟା ଆଉଥରେ
it is the place of jurisdiction my lord
ଆରେ ଆପଣ ନିଜେ କୁହନ୍ତୁ ନା ଆପଣ ସୁପ୍ରିମ କୋର୍ଟ ନୁହଁ କି ମୁଁ ନୁହଁ ଆମେ ପଢିବା ମୋର କାମ ହେଲା ପଢିବା ପଢନ୍ତୁ 16
para 15 ରୁ ଆରମ୍ଭ କରୁଛି ଆଜ୍ଞା
ପଢୁନାହାନ୍ତି
jurisdiction of ଆଜ୍ଞା the protection of women from domestic violence act as the object behind the enactment of would indicate is to provide a civil remedy.
So that is mind. I have rendered that judgment also. PWD रे जोटी से कहबे सेठी हबो. आपण 498 तक कर सलेनी.
एटा 498 दीटा ता परगो अछि.
हां ता 16 टा पढंतु. So
with therefore
I support from get support in domestic violence. Citation आउतरे कहले.
और the citation जो रूपाली देवी versus state of
citation रूपाली नो पाटिना रूपाली देवी.
पाटिना रूपाली देवी.
Citation.
Sorry my lord.
तो जड़े साइड करूचनी गले एआईआर एससीसी
आई
आउ आईएनएससी तीनटा करूचनी तीनटा डिसीजन मो रिलाय करछि तीनटा गोटे डिसीजन
para 7 lordship I have mentioned my lord
कौन सा पारा 7 अरे साइटेशन टा दियंतु सर
Criminal Appeal 71 of 2012.
मते सेटा दियंतु हबनी आज करबनी आज କହିବ ତ ଆଜ୍ଞା ମୁଁ ନାହିଁ ବାର ଆଣ୍ଡ ବେଞ୍ଚରୁ ଆଣିଛି
Sorry, my lord.
ସାଇଟେସନ ନାହିଁ ସିଧା କହିବେ ମୁଁ ଭାବୁଛି ଯେ ଆପଣ ଧରିଛନ୍ତି ମତେ କହୁନାହାନ୍ତି ନିଶ୍ଚିତ ଆପଣ ଡାଇରେକ୍ଟଲି କହିବେ ମୁଁ ମୋର ସାଇଟେସନ ଦେଇଦେଇଛି
ଏଇଟା ସାଇଟେସନ ରେଫର କରି ଆଜ୍ଞା ଆମ ହାଇକୋର୍ଟ ଟ୍ରାନ୍ସଫର ଗୋଟେ କେସ୍ କରିଛନ୍ତି ଆଜ୍ଞା କୋର୍ଡିନେଟ ବେଞ୍ଚ ଆଜ୍ଞା ଏଇ ଜଜମେଣ୍ଟ କୁ ରେଫର କରି
ସେଇଭଳିଆ ମୋର ପାଣ୍ଡିତ୍ୟ ନାହିଁ
ସରି
ଡାଇରେକ୍ଟ ଡିସିଜନ ଅପୋଜ ମୁଁ କେମିତି କରିବି 16 ରେ କହିଲା ଯେ ଯୋଉଠି ସେ ରହିବେ ସେଇଠି ତାଙ୍କର କଜବ ସେଇଠି ଫାଇଲ କରିବେ ଆପଣ ତ ଇଣ୍ଟରପ୍ରିଟ କଲେ ସେ ଯୁଆଡେ ଯିବେ ତା ସିଆଡେ ସେ କେସ୍ ଯିବ ପଢୁନାହାନ୍ତି ଇନଫ୍ୟାକ୍ଟ ଆପଣଙ୍କୁ ମୋ କଥାଟା ଅପିଲ କରୁଛି ସେଥିପାଇଁ ଆପଣ ପଢିବା ବି ବନ୍ଦ କରିଦେଲେ ଥରେ ପଢିଲା ପରେ when I said it is directly against you ଆପଣ ପଢୁନାହାନ୍ତି it has appealed you ନହେଲେ ଆପଣ ପଢିଥାନ୍ତେ ସାଇଟେସନ ଟା ଦେଖିଲେ
ଆଜ୍ଞା
ଉପରେ ଲେଖା ହେଇଛି ଦେଖନ୍ତୁ 19.5 ACC 384 so if following 16 how the court will transfer it
No, not I am
ଆପଣଙ୍କ ଆପ୍ଲିକେସନ TRPC 407 ରେ
TRPC criminal my lord 407
407 ରେ ଆପଣ 16 says what
Lordship may kindly say 407 ground of transfer my lord lordship high court jurisdiction
ଗୋଟେ ସାରନ୍ତୁ let us not jump around
my lord that is a jurisdiction my lord one issue my lord
କଣ କରାଯିବ ଆଜ୍ଞା
para 16
କଣ କରାଯିବ ଆପଣ you should have ଆପଣ ଏଇଟା ଫାଇଲ ଆର କୋର୍ଟରେ ଦେଖେଇଥିଲେ
my lord
ଅଦର ଯୋ ଆର ମ୍ୟାଟର କହୁଛନ୍ତି କୋର୍ଡିନେଟ ବେଞ୍ଚ ଟ୍ରାନ୍ସଫର କରିଦେଲେ
ନା ମୁଁ କରିନି ଆଜ୍ଞା ଆଉ ଗୋଟେ ରିପୋର୍ଟେଡ ଜଜମେଣ୍ଟ
ଟ୍ରଷ୍ଟ ୟୁ
ଗୋଟେ ରିପୋର୍ଟେଡ ଜଜମେଣ୍ଟ ହେଇଛି ମୁଁ ସେଟା
ଟ୍ରଷ୍ଟ ୟୁ ସର ଆପଣ ଯେତେବେଳେ କହିଲେ ଯେ ସୁପ୍ରିମ କୋର୍ଟ କହିଛନ୍ତି ଯେ ଯୋଉଠି ୱାଇଫ ରହିବ ସେଠି ଟ୍ରାନ୍ସଫର ହେଇଯିବ ଆଇ ଟ୍ରଷ୍ଟେଡ ୟୁ ବଟ୍ ଆଇ ଇନସିଷ୍ଟେଡ ଅନ୍ ରିଡିଂ ଇଟ୍ because whatever little ability I have to read then can only understand and when I read it it is the exactly the opposite proposition what you are saying Mr. Niranjan Singh लिखले opposite party Mr. Prem Kumar Mohanty for OP1 OP23 black the petitioner wife in the marriage the petitioner the petitioner is the wife in the marriage she has filed she has filed the present application under section 407 of the
CRPC
Code of Criminal Procedure, 1973. CRPC ର full form କଣ?
criminal procedure code
କିନ୍ତୁ act ନାଟା କଣ?
1974 my lord
act ନା କଣ? act ପଢିଲେ?
the code of criminal procedure code 1973
CRPC କେମିତି ହେଲା? କୁହାଉଛି ଠିକ ଅଛି but there are subtle CPC
code of criminal civil code
civil procedure code ଆମେ CPC
civil
କହୁଛେ but that is code of civil procedure anyway particular ହେଲେ ଭଲ it becomes so easy ଏ ଜଣେ କହିଥିଲେ ବଡ ସଦ୍ଗୁରୁ ଯେ ଆପଣ ଯଦି ସିଷ୍ଟମାଟିକାଲି କରିବେ ଜିନିଷଟା ବହୁତ ସୁବିଧା ହେବ आमे जदि चेष्टा करिया नॉन पर्टिकुलर हबो बहुत डिफिकल्ट है कोन लिखु हाँ कोड ऑफ क्रिमिनल प्रोसीजर seeking transfer of city case number 625 of 2024 arising out of Hon'Ble PS case number 249 of 2024 pending before the Lorded JMFC into bracket V Bhubaneswar. The PS case PS case arises out of the complaint lodged by the FIR lodged by the wife herself, the petitioner wife herself, which has led to the initiation of the city case. On being asked how the complainant herself, after initiation of the proceeding since 2024, can seek transfer of the trial, transfer of the city case, trial, transfer of the pending trial, The Lorded Counsel for the petitioner refers to judgment of the Honorable Apex Court in Rupali Devi versus State of UP.
Another judgment I have seen.
Colon into bracket 2019 5 SCC Unit 4 paragraph 16. Paragraph 16 टाको reproduce कर देवे. In considered opinion of this court, paragraph 16 of Rupali Devi Supra is not on the point to support the contention of the petitioner, as it is contended by the Lorded Counsel for the petitioner that since the petitioner has herself shifted to Tenkanar, the trial has to follow her at Tenkanar. In considered opinion of this court, Rupali Devi versus State of UP does not say so. Rather, it says rather at paragraph 16 it lays down that the wife at her place can initiate the proceeding, which has happened at under the Hon'Ble PS case, which has happened by the Hon'Ble PS case at Bhubaneswar and is being tried at Bhubaneswar. It is further submitted by the Lorded Counsel for the petitioner that it would be convenient for the persons who are named and facing trial in the said city case. In the context of said submission, it has to be noted that the persons who are facing trial have not approached this court, nor it is a joint petition by the complainant, by the petitioner, complainant, and the persons named in the FIR but seeking transfer. Yes. It has also to be noticed that Rupali Devi is pronounced in the context of Domestic Violence Act. So and so, which is meant to give relief to the lady in distress. At paragraph 15 of Rupali Devi, the following has been held. Yes, another decision.
Abdul M. Damel and another versus CBI New Delhi. That is the convenience of the party. The court has been transferred the matter.
So the key file kala. He is not the party here. They are not objecting. Upon Judah CBI Kohibe, they take on private party thile. Conference of the parties upon Niche Kuchanti, upon other side Kuchanti, Ajit, the other side has appeared. ଆପଣଙ୍କର usually transfer हुए case टा at the instance of the person who is facing trial.
Trial mirror.
ସେ ଦେଖୁନାହାନ୍ତି
ଏଥିରେ
ସେଇଟା ମଧ୍ୟ ଦିଅନ୍ତୁ ବାହାର କରିବେ। You are just arguing the converse, sir. ଆପଣ ସବୁ citation ଆପଣ against ଆଣିଛନ୍ତି। ମୃଦୁଲ ଡାମଲେ ହେଲା versus CBI ହେଲା। ଦେଖନ୍ତୁ ଏଠି on the ground of convenience of the parties and the witnesses cited in the charge sheet by the prosecution. This is a case of Maharashtra. Witnesses at Maharashtra and Mrudul is facing trial. ଏଥିରେ ଆପଣ ହଉଛନ୍ତି complainant. ଆପଣ trial face କରୁଛନ୍ତି ନା ମୁଁ ଭୁଲ ବୁଝିଛି କୁହନ୍ତୁ?
ନା ଠିକ ବୁଝିଛନ୍ତି।
ତାହେଲେ ଠିକ ଅଛି। କାରଣ ଡୋମେଷ୍ଟିକ ଭାয়োଲେନ୍ସ ମୁଁ ଆପଣଙ୍କୁ ପଚାରିଥିଲି ସେତେବେଳେ ଇନଫ୍ୟାକ୍ଟ ଆଜିକାଲି ଡୋମେଷ୍ଟିକ ଭାয়োଲେନ୍ସ mother in law is filing against the lady. But here it is a 498A filed by you against the in-laws family. So Mrudul is not, Mrudul is facing trial. That is what I was also dictating. ଆପଣ trial face କରୁନାହାନ୍ତି ତ?
ନାଇଁ ମୁଁ ତାହେଲେ ଠିକ ଅଛି। କନଭିନିଏନ୍ସ ପାର୍ଟି
କାଉନସିଲ ଫର ଦ ସେଟା ମୁଁ କେମିତି ଜାଣିବି ଆଜ୍ଞା ଆପଣଙ୍କ ତାଙ୍କ ସହିତ ଯୋଉ ଭଲ ସମ୍ପର୍କ ଅଛି ଯାଇ ସେ
ଭଲ ସମ୍ପର୍କ
I cannot rely upon Mrudul or Rupali because it is Mrudul is by the person who is facing trial.
It will difficult on part of me, madam. I am going to Bhubaneswar.
Sir, you are a evidence, you are a witness. You will be summoned. Upon you have to rely on a case law where the witness, the trial has to be place of the stay of witness.
I will supply.
Now the learned counsel for the petitioner has adjournment. Now the learned counsel for the petitioner seeks adjournment. To address further. The petitioner relies on Mrudul versus CBI to submit that this court has to look for the convenience of the parties. This Mrudul pura citation de debe. There can't be any two opinions that Mrudul was the person facing trial, the cause of action, as well as the evidences and the witnesses were at Maharashtra. But in the case at hand, the petitioner is not facing trial, rather she is the complainant and is a witness for the prosecution. Stop. The matter has been listed for presentation in the week commencing
on 30.
Week commencing on 30. Now, we are going to debate on 30. Yes, next.
Item 6.
Yes.
Item 8.
Also.
Item 10.
No, I'm asking for adjournment, my lord.
Mrs. S. Das for the petitioner.
Yes, ma'am. The lordship may listed after vacation.
Yes. Says Das for the petitioner, Mr. Prem Kumar Manti for the opposite party. The matter was heard at length on 17/4/2026. And adjournment was sought for by the Lord Counsel for the petitioner to address further. Today, the Lord Counsel again seeks adjournment. Now, accordingly, the matter shall be listed for fresh admission in the week commencing. 29. ଆପଣଙ୍କ ଯୋଉ କେସ୍ ଗୁଡାକର ନାହିଁ କିଛି ତାକୁ ରଖନ୍ତୁନି
I have to find out.
because you are not giving any guarantee to the client. ଆପଣଙ୍କ କେସରେ କିଛି ନାହିଁ ଆପଣଙ୍କର ଗୋଟେ ରିଲାଏ କରୁଛନ୍ତି ଗୋଟେ ରିପୋର୍ଟ ଉପରେ I asked you that whether it is binding you check on this and whether it is a relevant
I'll
consideration.
find out certain judgment of this.
There is not a single judgment. And don't cite judgments like Mr. Singh directly against him. Were you present? Mr. Singh cited two decisions directly against the he's the complainant seeking transfer, citing the decisions where it says it can be transferred at the instance of the person facing trial.
No,
ADM, while rejecting your application, has relied on
ADM
that.
is not rejected.
Whoever, the authority has relying on judgment, has taken note of the source. I mean, what is your name, and suggested that in that name there is already another society. You are relying on a report of an authority. Then it was asked to you that what is the value of that report, statutory value, or it is binding or whatever. There you struggled and adjourned.
That effect, it is
Nothing.
there.
That's nothing.
You let me grant me only one chance and it will not.
1 month is a good amount of time.
Yes.
So 1 month is a good amount of time to argue a matter. Even one day, upon just seriously prepare karibe, 1 day rehebo. But jo decision upon paichen aaj bhi koi pari tha.
It's our. I need certain more judgment.
You are on a road to nowhere. There is no such judgment, which will say that the report will be binding on the administrative authority, statutory authority.
No, I am not saying that.
Second point is much more difficult. That whether this court can substitute the view of the administrative authority.
Well, I am certain. I am on point that even if
evidence act no कहले नि म administrative law पचले आपण मते reply देले evidence act.
No, administrative evidence act कोई नहीं है. It's a law. Let's
remember. Okay. Being particular is a good habit. Always try to be particular. Upon concentrate karantu. I have already adjourned the matter. That is why I am discussing. I have not registered. Did I register adjournment?
No, my lord. I have consulted.
How do you grow in your profession?
No, I have consulted one senior advocate. He suggests there's some judgment. That's why I took time, my lord.
See, যদি নিজে পড়থান্তে भी पढ़े থান administrative law रे आपनको से जो basic decision उडाका नियति पढ़ेको पड़ियो. If you start arguing in read courts, this is judicial review of administrative action, say fundamental principle उडाका देखियो पढ़ेको पड़ियो. About at least 60-70 you have to read those. Whoever. ଆପଣଙ୍କର ବିଶେଷ କିଛି ଡିସିସନ ନାହିଁ এই ପଏଣ୍ଟ. ଏଥିରେ ଲିଡିଂ ଆର୍ଗୁମେଣ୍ଟ କଣ ହବ? ବେଷ୍ଟ ଆର୍ଗୁମେଣ୍ଟ କଣ ହବ? Wednesbury principle of unreasonableness. If the action of the administrative authority is false foul of Wednesbury principle, haba. तापर possibility develop hela Wednesbury पढिचंती.
Sorry, my lord.
Wednesbury पढिचंती.
Sorry, I did.
Senior advocate कोन कहले आपन?
No, I went through section 3 of registration act. It says that no two.
ଆପଣ ତ section 3 ରେ ତ ଗଲେ ବହୁତ impossible ହବ ଆପଣ. The reason being the authority has given a reason. Even in revision or appeal, this court cannot substitute its own view. We have been discussing. Wednesbury से कहले आपन senior कहले Wednesbury कहले.
No, से कहले कि
Tata Cellular कहले.
Even if in the one state also two association can run, even if there is certain resemblance in between two association, to that effect I'll
direct decision थिबो. बडा कर भाबिले हबो कि
say decision term I'll need to find out.
सेमति किछि decision बाहरियो. This court आपनकर
I'm taking only one chance.
अरे मु तो आपन chance दे सलेने आपन again you are always many times you are out of context. After giving you the chance and discussing with you how you have read and what you have read, how you can seek a judicial review of administrative action. Associated Provincial Picture House versus Wednesbury Corporation. सेटा पढियो तब टाटा सेल्युलर अछि तापर पढिबे So that upon it, this is not a statutory, he is an administrative authority. Whether he can, court can compel that, see joda upon joda chahibe debe, Mr. Sethi, Mr. Mahanti chahibe seta diya haba semti. Whether that discretion is to be left to the authority or you will decide or court will decide. Yes, next.
Obliged.
Item 11,
Your Lordship, due to the unfortunate demise of the opposite party, the matter has become infructuous. So Your Lordship may kindly dismiss the matter as withdrawn. Your Lordship, I am for the
Has he
petition.
died in suspicious circumstances?
Huh?
He has died in normal.
I don't know, Your Lordship. I
Because
have no idea.
in one matter,
Yes.
then there is allegation that the others, the lady was killed.
Your Lordship.
Because so when stark, so I thought that this could be the second thing.
No, Your Lordship.
I remember the lawyer actually. Both the lawyers I remember. So they took instruction. So can you file that memo?
Yes.
You have the death certificate or how you are stating?
No, I don't have the death certificate, but I have prepared a memo.
Can you file that and record it? Your name, madam?
SK Jabina Zahid. I am for the petitioner.
Sheikh Jamina Jahid for the petitioner. Opposite party blank. Is submitted by the Lorded Counsel for the petitioner. So लिखुंतु on 26/2/2026 the matter was heard at length and the following order was passed. Reproduce कर दें. है ना? Today, the matter being in the list, memo of date is filed by the Learned Counsel for the petitioner. Indicating that the opposite party has unfortunately passed away during pendency of the petition. Memo shall be taken on record, scanned copy be updated. Stuff. Accordingly, the petition stands disposed of. Yes.
item 13,
12 तक को upload कर दे.
Item number 13.
Yes.
The noting is there, my lord. The matter may not be come under the heading of orders, but it should come under the heading of admission. The noting is that the opposite party ought to serve the copy of the petition to the petitioner, which I have already been received.
This is what, sir? This must have come from with a certain purpose. RPFM seeking what?
Arising out of common judgment passed in 125 maintenance proceeding.
Yes.
So both are before lordship. There are two RPFMs.
Yes.
One by the wife and husband, because this wife and husband I did not repeat because all now that is dissolution marriage confirmed by alone Supreme Court. Decree of divorce is your lordship has nothing to say your lordship. According to Justice Sinha, my lordship can remember. Termination of marriage, matter proceeding, your lordship had disposed of a judgment. Their wife, Sasita went to police.
Challenging the grant of, decree of divorce.
There are two things. Your lordship said decree of divorce, your lordship directed. At the same time, regarding permanent alimony, your lordship said she is not entitled. Approving the order passed by the learned family, saying that she is not entitled. With reasons, your lordship also gave additional reasons to justify that she is not entitled to permanent alimony. Let's matter went to Supreme Court at their instance first. Honorable Supreme Court, while approving the decree of divorce mirrors, said so far as permanent alimony is concerned.
25 before the family.
Yes, if they remanded the matter, they removed the matter, setting aside directing the family court to decide after checking after checking evidence. So that is yet to be taken up there. So now this is 125, there's 125, 15,000 direction on that. They have challenged the order saying that we are paying for enough money. We have come before setting a certain order. Matter is now currently pending that the honorable should go directly to Pavilion to take this.
So
therefore,
so Mr. Behra,
My lord,
so now as far as 25 is concerned,
my lord.
so that will take care of 125 also.
yes, yes.
ଆପଣଙ୍କର କେତେ ଟଙ୍କା ଡ୍ୟୁ କେତେ ଟଙ୍କା ହେଲାଣି?
I have
due
been paying
to-
till now. We are
Actually, you
continuing.
are
my lord.
continuing to pay.
Yes, yes. We are continuing that payment.
The husband is getting 1
Sir,
lakh.
ଦେଖନ୍ତୁ, sir, first of all,
Yes,
let us make it a promise to each other that we will go by the pleadings and go by the law.
my lord,
Let us not have these extempore speeches.
my lord.
If you differ with whatever the learned senior has expressed, your
My-
senior has said
my-
that those legal aspects are not correct, then straight away can say that.
My lord.
125 is not pending, 25 is not pending. Supreme Court has not remanded the directing consideration of Section 25 application for permanent alimony.
My lord.
Are you differing there? That is the starting point. You please say.
So I'm giving a copy.
No. So let him say.
A record, only for record news. Let him say yours.
Yes.
For your lordship's record, I am giving you.
File it with a memo.
So that your lordship, yes, allow the memo.
ତାଙ୍କୁ ଗୋଟେ କପି ସର୍ଭ ଦିଅନ୍ତୁ।
Again.
So are you differing there? Anything factually ଆପଣଙ୍କର procedurally ଆପଣ differ କରୁଛନ୍ତି କି?
ନାଇଁ ପ୍ରୋସିଜର କିଛି ଡିଫରେନ୍ସ ନାହିଁ ଅନରେବଲ ଆପେସ୍ କୋର୍ଟ ଡାଇରେକ୍ଟେଡ remitted the matter to for consideration of a permanent alimony. 25 is there.
That is always available.
Any grievance is, my lord. The order passed by the learned judge family code under section 125 looking to the salary of the husband passed order of rupees 15,000.
Very good ground, sir. Very good ground. You are
My
agree.
commission is our more little. Thereafter, his salary is 1,18,000. Out of that, 15,000 has been passed. I, being aggrieved on that order, filed this RPFM before this honorable.
Date, filing date.
My lord.
Date, ତାରିଖ କୋଉ ତାରିଖରେ ଫାଇଲ କଲେ?
Let me assist your lordship.
I
ତାରିଖଟା ମୋର ମନେ
I have the brief before me 13/2/23 ରେ ଫାଇଲ କଲି।
ଆଜ୍ଞା।
So ସେଟା କନସର୍ନ ମାନେ ତାଙ୍କୁ ନ କହିଲେ ସେଟା ଭାବିବେନି ବୋଲି ମୁଁ ସେଥିପାଇଁ ତ ପଚାରେ। ଆପଣ 13/2/23 ରେ ଫାଇଲ କଲେ।
ଆଜ୍ଞା।
ଇମ୍ପୁଟ ଜଜମେଣ୍ଟ ଟା କେବେ?
ଇମ୍ପୁଟ ଜଜମେଣ୍ଟ ହେଲା
7/12/22।
ଆଜ୍ଞା।
କରେକ୍ଟ?
ଆଜ୍ଞା। 17/12/22।
এটা ଭୁଲ ହେଇଗଲା ମୋର। ଦେଖିବାକୁ ପଡିବ। ଆମ ରେକର୍ଡରେ ଭୁଲ କରିଦେଇଛ। I develop a habit of reading. So 17/12 ମୋର 7/12 ଲେଖା ହେଇଛି। 17/12 17/12/22 ଫାଇଲ କଲ 13/2 ଫାଇଲ।
ଆଜ୍ଞା।
MATA ଟା କୋଉ ଦିନ ଫାଇଲ ହେଇଥିଲା? MATA
ମାତା ତା ପରେ ଜାନୁଆରୀ କିମ୍ବା ଫେବୃଆରୀ
ହେଲା ଠିକ ଅଛି। ମାନେ 22 ନା 23 ମସିହାରେ?
23 ମସିହାରେ।
23 ମସିହାରେ। 2023 ରେ ମାଟା ଫାଇଲ ହେଲା।
ଆଜ୍ଞା।
ମାଟା ଜଜମେଣ୍ଟ ହେଲା।
ଆଜ୍ଞା।
11/9/24। ବର୍ତ୍ତମାନ ଯୋଉଟା ଆପଣ ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି,
ଆଜ୍ଞା।
ବର୍ତ୍ତମାନ ଯୋଉଟା ଆପଣ ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି, what you are arguing, that was on 17/12/22. Then SLP judgment କୋଉ ଦିନ ହେଲା? 12/3/26. So that you have to address. You being dissatisfied with the quantum of 125 maintenance is perfect. Nobody is saying that. They may say that we also want lowering of the amount, or no, you are not entitled. But both of you, this question to common question. After determination by this court of MATA, decision of this court and judgment of the Supreme Court, directing 25 to be tried by the trial court, then what is the future of this case?
This RPF, my lord.
Have you read Rajnish versus Neha?
Yes. Yes.
I have read, but
Paragraph, two paragraph, this aspect has been dealt with.
authority pori
now ପଢନ୍ତୁନି ଆଉ ପଢିଲେ କଣ ହବ ନା ଆପଣ ଏଟା 22 ମସିହାରୁ ଏଟା କେବେ ହେଲା 4 ବର୍ଷ ହେଲା ପେଣ୍ଡିଂ ଅଛି ସେ ଭାବୁଛନ୍ତି କିଛି ଗୋଟେ ହବ ଆମର ଗୋଟେ କର୍ତ୍ତବ୍ୟ ହଉଛି as law professionals me also and you that let us not give a hope that something is going to happen. The reason being now 25 is the direction of the apex court.
That is under pending.
It has to pending. It has to be pending. Not decided. Decided ହେଲେ ତ ଆପଣ ଯାହା କରିବେ decided ହେଲେ ଆପଣ 25 ରେ ବି challenge ବି କରିପାରିବେ. You will again go to Supreme Court. Lawyers are not complaining. But now at this stage, keeping this matter pending will not be in your interest. That's the first consideration. Second, this case has no future after the decree of divorce has been granted, 25 rejected by High Court. Though it's a division bench, I may not agree with that also. But it is a division bench decision. Whether alimony to be granted or not. But the Supreme Court has now decided finally. 25 has to be considered.
Rajnish is very clear.
And Rajnish is a
judgment is clear, but I have to go through
again. ଆପଣ ଯେତେ ଥର ଗଲେ ବି ଆପଣ unclear ହବ that is a problem there, mister. There is a problem there. Because the Supreme Court, what the Supreme Court has said, that it has to be circulated to all high courts and all courts. You have the advantage of in the denial that ମୁଁ 3-4 ଥର ପଢିଲେ ଭଲ କି ହବ. But we don't have a choice as a court.
conclusion
ଟା ତ ଆପଣ you have that advantage. ଆପଣ କହିଲେ ହବ ଗୋଟେ କୋର୍ଟ କେମିତି କହିବ ଯେ ମୁଁ ରଜେଶ versus ନେହା ପଢିଲି ବୁଝି ପାରିନି ଆଉ ଟିକେ ପଢିକି ଆଉ ଥରେ ଦେଖିବି କୋର୍ଟ ତ କହିପାରିବି ନା I cannot record that. We have that but as a lawyer you can say ଜାଣି ହଉନି କଣ କହିଛନ୍ତି.
Sorry to say, my friend didn't stop here. He has filed 4 applications before the court below, praying for modification of the amount.
No, not modification. That is under section 127. 127 spirit is different.
RPM file କରିକି ସେଠି ଆପଣ କହିଲେ
ସେଟା ତ more serious. ଆପଣ ଯଦି 125 ରେ 3 ରେ modification ଚାହୁଁଛନ୍ତି ତାହେଲେ RPFM ରେ କେମିତି decide ହବ?
Modification ଚାହିଁବି alteration ଚାହ
କଣ ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି କଣ ଏଟା କେଶବାନନ୍ଦ ଭାରତୀ ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି କି ଗୋଟେ ଭେରି ସିମ୍ପଲ କେସ୍ ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି ଆମେ ତ କେଶବାନନ୍ଦ ଭାରତୀ ଲେଭେଲକୁ ନବା କାହିଁକି ଆପଣ ଗୋଟେ 125 ଚ୍ୟାଲେଞ୍ଜ କଲେ ସେଇ ଯୋଉ 125 3 ପାୱାରଟା ଏଇ କୋର୍ଟର ନାହିଁ ଏନହାନ୍ସମେଣ୍ଟ ଅର ମଡିଫିକେସନ ପାୱାର ଏଇ କୋର୍ଟର ନାହିଁ ଅରିଜିନାଲ କୋର୍ଟର ଅଛି ସୋ ହ୍ୱାଇ ସୁଡ୍ वी ବଦର अबाउट ଆପଣ ଯଦି କଲେ that's a good strategy. The reason being at least you get a more forum, court will give a finding. ସେଇଟା ବିଷୟରେ ଆଉ କିଛି କହୁନାହାନ୍ତି ସେ ବି କ୍ଲିୟର ହେଇଯିବ ଆପଣ ବି କ୍ଲିୟର ହେଇଯିବ 128 ରୁ ପଢିବା ଆରମ୍ଭ କର ଅଳ୍ପ ଅଛି ମୋର ସେ ଡିଫିକଲ୍ଟ ହଉଛି ମୁଁ ବର୍ତ୍ତମାନ 128 ବୁଝିପାରୁନି ବୋଲି କହିବା ଭାରି କଷ୍ଟ ତା କ୍ୟାପସନଟା ପଢନ୍ତୁ ମିଷ୍ଟର ରାଉତ ଏ ଆପଣ ଏଥିରେ ନୁହନ୍ତି କଣ ୟୁ ଆର୍ ନଟ୍ ଦ କାଉନସିଲ ହଁ ଠିକ ଅଛି 128 ଉପରେ ଯୋଉ ଲେଖା ହେଇଛି ପଢନ୍ତୁ
issue of overlapping jurisdiction.
ହଁ ସ୍ଲୋଲି ପଢନ୍ତୁ we are exactly dealing with that issue of overlapping jurisdiction pardon
To overcome the issue of overlapping jurisdiction and avoid conflicting orders being passed in different proceedings.
ଆପଣ ସେଟା ଶୁଭୁନି ମାଇକ୍ରୋଫୋନ
ଆଉ loudly ଟିକେ କହିବେ.
ସିଏ କରିଦେଲେ ଆପଣ ପଢନ୍ତୁ don't get distracted concentrate
To overcome the issue of overlapping jurisdiction and to avoid conflicting orders being passed in different proceedings, it has become necessary to issue directions in this regard so that there is uniformity in the practice followed by the family court, / district court, / magistrate court throughout the country We direct that.
We direct, or can you read that?
Man, where a successive claim for maintenance are made by the party under different statutes, the court would consider an adjustment or set off of the amount awarded in the previous proceedings while determining whether any further amount is to be awarded in the subsequent proceeding. It is made mandatory for the applicant to disclose the previous proceeding and to order passed therein in the subsequent proceeding. If the order passed in the previous proceedings requires any modification or variation, it would be required to be done in the same proceeding. Then next part is payment of maintenance.
Say, tapore, bakita ku out dekhi do. Yo. Apno pakhare achi jota three Sahoo do.
Para 60, I think.
So Rao, you can take from your.
Para
ଏଇଟା ତ ଆପଣଙ୍କର ଫାଇନାଲ ଡାଇରେକ୍ସନ ଅଛି ସେଥିପାଇଁ 6 ପାରା ରୋମାନ 6 ନାଇଁ ଆଉ ଗୋଟେ ଜିନିଷ ଅଛି ସେଥିରେ 134 ଟା ଟିକେ ପଢନ୍ତୁ ଜଷ୍ଟ ତା ପର ପେଜ 134 ମିଷ୍ଟର ରାଉତ ଆପଣ ଗୋଟେ ଦେବେ
पूरा लास्ट पर
My lord, a copy of this judgment be communicated by the Secretary General of this court to the registrars of all high courts, who would in turn circulate it to all the district courts in the states. It shall be displayed on the website, all district courts, family courts, courts of judicial magistrates for awareness and implementation.
So that is again a 141 direction. Eta etre bar association include heini. Purposefully kori na. But this is not the. So now the problem is that there is a 25 application pending directed by the Supreme Court and 125 revision application pending here.
And so also the variation application is
application
is there.
Where it should go.
That is to be decided by that court. Supreme Court has remanded. Yes.
In view of Rajneesh versus Neha.
Yes, sir.
So since 25 was not there, that is how I highlighted. Mr. So there I highlighted the date. 17-12 re jota thila facts 17-12-2022 and where we stand today is completely different. By efflux of time, if this matter could have been taken before prior to the MATA, at least by the High Court, 11-24. Then there was a future of this litigation. Yes, this litigation doesn't have a future. That you must understand. And since you have already filed 125-3, or that
127,
127, whatever. X provision. So that should be taken up before the by the same court. So today or tomorrow, when do you want?
That observation or shipment is for.
Yes.
What?
No. Dispose of credit.
Yes, dispose.
Because you must understand that every time you argue now, since you have agreed, I'll tell you. The other side I was not telling. Every time you stand up to argue this, they will cite Rajneesh versus Neha, para 134, and say that parallel proceedings should not continue. And of course, when you filed, it was not pending. ଆପଣ ଯେତେବେଳେ ଫାଇଲ କଲେ 23 ମସିହାରେ 22 ରେ ଜଜମେଣ୍ଟ ହେଲା ପେଣ୍ଡିଂ ନଥିଲା ବଟ ତାପରେ ତ ଯାହା ହବା କଥା ତ ହେଇକି ଆଟଲିଷ୍ଟ ଇଟ ହାଜ ଆଟେଣ୍ଡ ସମ୍ ଫାଇନାଲିଟି the ଆପଣ appearance that Mr. First matter ରେ ଆପଣ Mr. RPFM 44/2023 Mr. RN Behera and Mr. GN Raut for the petitioner. Mr. Jagabandhu opposite party like Mr. Jagabandhu Sahu, senior advocate, along with Mr. Panigrai, Mr. R. Panigrai for the opposite party. ता तळुक लिखिबे RPFM 85 of 2025. Mr. Jagabandhu Sahu, senior advocate, along with Mr. R. Panigrahi for the petitioner. Mr. G.N. Raut, Gajendranath Rao, G.N. Raut, along with Mr. And Mr. Robinaran Pera for the opposite party. The judgment here is the RPFM 44 of 2023 has been filed by the wife in the marriage, challenging the judgment dated 7/12/2022, passed by the learned Family Court Dhenkanar in criminal proceeding number 109 of 2021. Hello. Date exactly. The application was filed under section 125 of CRPC by the wife in the marriage. The marriage having been solemnized on 13/7/2020. Her application was favored. The wife had claimed rupees 40,000 as monthly maintenance. The application was favored. However, directing payment of monthly maintenance at the rate of rupees 15,000. Without specifying, from the date of filing of the application under section 125. By filing the revision under section 88, the filing revision under section 401 of the CRPC, read with section 19 of the Family Courts Act, the wife in the marriage petitioner sought for enhancement of the quantum of monthly maintenance. The RPFM 85 of 2025 is by the husband in the marriage, seeking seeking revision of the judgment, denying liability. Upon pura zero denying his liability to pay monthly maintenance, to set aside the judgment passed by the Honorable Judge Family Court Dhenkanar. As the events have unfolded, though somewhat parallelly, MATA 129 of 2023 was filed before this court, challenging MATA details of record of nahi bote. Achi. MATA judgment achi ki? Right. Yes, I missed that. The MATA was filed by the wife in the MATA Sahoo test kaha dwara?
Sir, there are two MATAs. One arising out of restitution of value or right, the rejection family court, that is at the instance of the wife, and the one that was at the instance of the wife, and also another division of marriage. So there are two matters.
Both were rejected.
Both are rejected. No, restitution of rejected and dissolution allowed. Dissolution of marriage and
dissolution ki file kale? Dissolution ki file korte?
Dissolution file korte husband, that is allowed. RCR file korte wife, that is rejected. And both matters.
Section 13 file kale husband.
Dissolution marriage file kale husband.
Section 9 file kale
RCR file kale wife. Wife's application rejected, husband's application allowed. Both came before the option.
My lord, can I?
128
My lord,
and MATA 129. Sorry.
Can I leave?
Yes, please. MATA 128 of 2023 was filed. MATA 128 and 129 of 2023 were filed before this court, challenging the common judgment dated 21/2023 passed by the Honorable Judge Family Court Dhenkanar, the said judgment was made in CP number 19 of 2021, filed by the wife in the marriage seeking restitution of conjugal rights under section 19 of the Hindu Marriage Act. And stop, no comma, bas comma, semicolon, comma par bindu. CP number 128 of 2021 was filed by the husband in the marriage seeking dissolution of the marriage under section 13 of the in 1A, IA and IB of the Hindu Marriage Act. Stop. Both the CPs were taken up together by the learned judge family court, were disposed of by a common judgment dated 21/2023, allowing the application filed by the husband for grant of decree of divorce and dissolution of marriage, whereas rejecting the application under section 9 filed by the wife seeking restitution of conjugal rights. Stop. The division bench of this court, of which the division bench of this court confirmed the judgment passed by the learned judge family court, made in both the CPs. This court also, the division bench also confirmed the direction of the learned judge family court regarding the wife in the marriage not being entitled for any permanent alimony under section 25 of the Hindu Marriage Act. So, appeal was filed before the Honorable Apex Court by the wife in the marriage in civil appeal, civil appeal number dash arising out of SLP number dash Tasmita Marana versus Hussein Kumar Marana. The Honorable Apex Court issued limited notice only with respect to the grant of permanent, only with respect to the permanent alimony. The Apex Court observed thus in our considered view to Neki. Disposed of fortune. The learned counsel for the learned advocate on record for the husband in the marriage files memo of date enclosing copy of the order passed by the Honorable Apex Court dated 12/3/2026, as well as the judgment of the division bench dated 11/9/2024. Serving copy thereof on the learned counsel for the wife in the marriage. Stop. Now this court is presented with a situation that during pendency of the revision application filed by both the parties in the year 2023 and 2025, there is a decree of divorce confirmed by this court by a judgment dated 11/9/2024. Also, order of the Honorable Apex Court and order of the Honorable Apex Court dated 12/3/2024. And as directed by the Honorable Apex Court, the proceeding under section 25 of the Hindu Marriage Act or a decision regarding permanent alimony is pending before the learned judge family court. Number account which has since been initiated upon the matter being remitted by the Honorable Apex Court and pending adjudication.
Same decide afresh.
Having heard learned counsel for the wife, both the learned counsel, Mr. Raut and Mr. Behra, for the wife, as well as learned senior counsel for the husband. In considered view of this court, in view of this court, comma, in view of the in considered opinion of this court, comma, in view of the directions contained in the decision, Rajneesh versus Neha. Paragraph 128, so heading the data. 28, paragraph 128.1, 128.2, 128.3, and 134. The application seeking permanent alimony under section 125 CRPC. Sorry, permanent alimony section 25 Hindu Marriage Act, along with the application said to have been filed under section 127. Right. What a provision that you had.
So 127 is the number. One BNS
of the CRPC into brackets since repealed and substituted by parametric provision. So journalist functionalist studies. Parametric provision contained in the text needs to be tried by the learned judge family court together. The Pulbur Likhibe, it is submitted by the learned senior advocate appearing for the husband that the wife has also filed an application under section 127 na Bharatiya Nagarika Suraksha file korche.
146 CNS.
146 BN.
So 40 has been filed by 146 BNS 2023 seeking alteration of allowance granted under section 125 into bracket section 144 of BNSS, which is pending adjudication.
Application also 146, CRP number but the same. See 146 of that.
Is submitted by the learned senior counsel that both the proceedings, that is under section 146 of BNSS, pending before court file kale, magistrate ka family court,
family court,
pending before learned judge family court, and the present proceeding filed under section
25.
Not 25. 401 of CRPC, challenging the earlier judgment under section 125 CRPC cannot be pursued simultaneously. That is submission.
Right.
It is taking the final judgment taking plan. Repairing about I have tried to capture in your presence whatever the submission so that both of you are satisfied. It is to remember that they important. Yes, yes, both are disposed of. Yeah. সেটা কইরি করি জুন আর মোর লিখি দেবে এটা স্যার কাহা ব্রিফ এটা দেখা তো বেরা স্যার না পানি রে স্যার কার
May I pardon to mention, my lord, item 28, my lord.
I'll come back. Though there is a special page,
My
But
lord,
I'll come back and take that.
I have some personal difficulty.
Whatever, sir, madam, adjournment se debe, but I have to pass orders.
My
Usually,
Specialist for again.
hopefully. Kali specialist at that time, actually, I have some, I have to join something at 4:30. I cannot continue. Kali भी से हला, Kali भी like.
हमारा जो 12 दही पकड़ा ना
ଆପଣଙ୍କର ଆପଣ ଆସନ୍ତୁ ସ୍ପେଶାଲି ସମୟ ଲାଗିବ ନା ନା ସେ ନୋଟିଂ ଅଛି ବୋଲି ସେ କହୁଛନ୍ତି ସେ ଲେଖିଛ ସେ ନୋଟିଂ ଅଛି ଯେ ଦ ମ୍ୟାଟର୍ସ ଅଫ ଦ ଲିଷ୍ଟ
ଦୁଇଟା ବେଳକୁ
ଆଜ୍ଞା ଆଜ୍ଞା
ଆଉ ସ୍ପେଶାଲ ଲିଷ୍ଟଟା ନେବେ ତେଣୁ ଆମେ ଯଦି ପଳେଇବାକୁ
Lords, I may be pardoned, my lords.
But
ଆପଣ ସ୍ପେଶାଲ ଲିଷ୍ଟ କଣ ଲିଷ୍ଟ
ଲେଖା ହେଇଛି 12 ପରେ ସ୍ପେଶାଲ ଲିଷ୍ଟଟା ନିଆ
ବାର ଗୋଟେ ଆଇଟମ ମାର୍କ କିଏ ଥିଲା
12 ଦି ରହିଲା
ଲେଫ୍ଟଓଭର କିଛି ନାଇଁ ସେ ତାମାନେ ଲେଖି ନାହାନ୍ତି ଲେଫ୍ଟଓଭର କିଛି ମୁଁ ଭାବିଲି ସେ ଶବ୍ଦରେ ଲେଖନ୍ତି ଯେ ଦ ମ୍ୟାଟର ଅଫ ଦ ଫାର୍ଷ୍ଟ ଲିଷ୍ଟ ଶାଲ୍ ବି ଟେକନ୍ ଅଫ୍ ଆଫ୍ଟର ସ୍ପେଶାଲ ନଥିଙ୍ଗ ଆପଣ ଡେଟ୍ ନେଇଯାଆନ୍ତୁ
Lords, I
currently. तो এটা মন্ডে କୁ ରହିପାରିବ 14 ଆଇଟମ ଟା
ସେ କରିବେ ଯାହା କରନ୍ତୁ
ଆଜ୍ଞା
ଆମର ଆପଣ ଯୋଉଟାକ ଇନସିଷ୍ଟ କରନ୍ତୁନି ବିକଜ ଆପଣଙ୍କର ମଣ୍ଡେ ୱିକ୍ ରେ ଆଜ୍ଞା ରହିଲାଣି 121 ନାଉ ସୋଜ 121 ଭଲ ଶୁଭ ଅଛି ଯାହା ବି ସାର୍ ଆର୍ଜନ କରିବା କଥା ସେ କହିଲେ ଡେଟ୍ ଦିଅନ୍ତୁ ବା ଯାହା କରନ୍ତୁ ବଟ୍ ଆଇ ୱିଲ୍ ପାସ୍ ଅର୍ଡର୍ସ ଆଫ୍ଟର ଆଇ କମ୍ ବ୍ୟାକ୍ ଟିକେ ଯିବ ଆପଣ ଟିକେ କୋଉଠି ଅର୍ଡର ଗୋଟେ ମାର୍କ ଆଉ ଯୋଉଟା ଡେଟ୍ ଦେବା କଥା ବୋଥ ସାଇଡ୍ ଚାହୁଁଛନ୍ତି ସିମ୍ପଲି ପୋଷ୍ଟିଂ କରିଦିଅନ୍ତୁ ସୋ ଦ୍ୟାଟ୍ less number of orders will be passed.
Item number 18, my lords.
Sir.
Item number 18, can it be taken up today, my lords?
Kali add karo tu.
Again, no problem.
Bench kote je tu heichi special bench, the noting nahi seta ko upare debate kariyo da. Abe dine se noting lokutla je rakhi na.
Sir, kali as.
18 kali add kar paribe. Kali ki pardon de.
Oblige me.
The matter having been fixed marked at 2 p.m. was called again after resumption of the proceedings post lunch stop. None appears for the petitioner, nor the petitioner is present. Sorry, none appears for the petitioner, nor any affidavit has been filed as directed by order dated 8/5/2024. In response to the mention made at the beginning of the day's proceeding, order number 2 dated 13/5/2026 was passed. The said order is reiterated in view of non-appearance of the petitioner or the learned counsel for the petitioner at the time when the matter was fixed to be called. Stop. Order number 380. Complete court. केटा किए करते तांका को पठे देले से करते शॉर्ट ऑर्डर तक कि अपन कर देले yes
I may be pardoned to mention, Your Lordship.
Yes.
Item 19 in today's list, Your Lordship.
the I mean the earlier list, not today's list, earlier list.
My Lord.
Now it is a special bench.
My Lord. So may I request, my Lord, that the matter may be taken up any date before vacation convenient to Your Lordship.
19 for admission पे अच्छे
My Lord.
for admission ना orders पे
Orders, my Lord, because I have filed an item.
देखो next week करन
11 से टाइम नहीं थे नेक्स्ट वीक
आज्ञा
11 टाइम नहीं थे ऑथर से कहते जणे बोली जणे
से आपन जणैले
No, my Lord, I have not been informed, my Lord.
कौन लिखो ताल अरे कितने नंबर आइटम
Ninety.
फ्लिप आप दियो पेपर उड़ा सी ता कंप्यूटर काम करन आपण क्लिप पे आपण एठी बसुन तो क्लिप एबे पेपर उड़ी जाउछ ना item 19 लिखिबे the matter is that is listed for orders in the first list for the day for this bench. The learned counsel for the opposite party sought for adjournment at the beginning of the day's proceeding, stating that he has informed the other side. Their appearance likely Mr. You are Mr. Agarwal, Ramesh Kumar.
My Lord, Ramesh Kumar.
19 Mr. Ramesh Kumar Agarwal for the petitioner. गोटे ऑर्डर जदि करिवे सबुडा तो बोधे किंतु सबुडा आपण पिटिशन
My Lord.
तीनटा कौन लिखे this proceedings he will public will inform the learned counsel for the other side Hello? After resumption of the proceeding post lunch it is mentioned by the learned counsel Mr. Agarwal for the petitioner that he has not been informed nor his consent was taken before seeking adjournment. Accordingly, the prayer made by the opposite party is rejected. The matter shall be listed for orders on aji kete 15 रही परियो 15 कर दियो.
I am obliged. My Lord,
So that's the-
similarly, my Lord, 21. That
21?
matter is today listed, my Lord. My Lord, Lordship, here what has happened, the IA has come up for impletion of party. What I have done, my Lord, the requisitioning authority was not a party. So I have made him the party.
aji को जाए गले हमें फर्स्ट मैटर टा फर्स्ट लिस्ट टा कल ही नहीं आसुन
My Lord,
only author भी mention नहीं
my Lord,
So it will
only
not be-
predicament is here. My
Tomorrow,
opinion is infructuous.
tomorrow please mention
My Lord, my Lord.
obliged
because at times by mentioning also the timing is adjusted
My Lord,
so that the only order remains the matter
My
is called by mention
my Lord,
even if the order is not passed the order is passed later on
my Lord.
so that helps So
My Lord,
tomorrow
only
mention.
prayer is, my Lord,
Yeah,
the
order ही
order.
तो आपण कंप्यूटर रे कर देबे आपण फाइल टा काढी के कंप्यूटर रे कर देबे when the order is dictated it is becomes difficult because it has to be signed returned then it is again comes back for listing
My Lord.
we are not yet completely actually paperless and perhaps it is impossible also to certain extent
My Lord.
so all this procedural part has to be done physically yes tomorrow 6 लिखंतु none appears for the petitioner though the matter is called twice over the matter was heard at length on 27/2/2026 the counsel for the petitioner sought for sought for adjournment on 9/4/2026 referring to the said order. To obtain instruction in terms of the order dated 27/2/2026. Stop. To grant further opportunity to the petitioner, the matter shall be listed for fresh admission in the week commencing 13/7.
Item 8
none happens for the petitioner, though the matter is called twice over. Apana sir achandi?
Yes, ma'am.
Yes.
May I plead, Your Lordship?
Yes, please.
Lordship, as
ଆପଣ earlier order dated 732026 ଦେଖିଛନ୍ତି?
yes, my lord, we had filed that affidavit as directed by this honorable court that the present petitioner is regularly paying apologies, the challan.
Affidavit ଟା କେତେ ଅଛି ଅଛି ବଟ୍ ଆପଣ ଯୋଉ ପ୍ରୋବ୍ଲେମ କଣ ହଉଛି କହିଲେ ରେଗୁଲାର ପେମେଣ୍ଟ କୁ 11 ପାରାଗ୍ରାଫ ରେ ଲେଖିଲେ ମୋର 3ଟା ଧାଡି ଦରକାର. You have to be very frugal in your expression in this sense.
My lord, if I may.
Order ଟା ହଉଛି the problem is that it did not be found out. ଆପଣ order ହେଲା ଯେ it is Meghraj na.
Yes, ma'am.
The learned counsel for the petitioner also shall also file the full lekha hai file the details of the payment already made pursuant to the order passed in the said proceeding or any other proceeding. ଆପଣ ଯଦି ସେଇଟାକୁ ଯୋଉ affidavit ଟା ଦଉଛନ୍ତି,
yes ma'am,
ସେ affidavit date of order କେବେ?
Date of order was 18/3.
15/1/26 ଆପଣ 15/1/26 को challenge କରୁଛନ୍ତି.
Yes ma'am.
So 15/1/26 ରେ ଆପଣଙ୍କର ଏରିୟର କିଛି ଥିବ? କିଛି କରେଣ୍ଟ ଥିବ?
Yes my lord.
So ଆପଣ ସେତିକି ଦେଖିବା କଥା ଯେ ଏରିୟର ବାବଦରେ ଏତିକି କରେଣ୍ଟ ବାବଦରେ ଅଙ୍କ ଡେଟ୍ ରେ ଏତିକି ହେଲା. ଆପଣ ତାକୁ 11 ପାରାଗ୍ରାଫ ର ଲେଖିଛନ୍ତି affidavit. Does it make any sense?
If I may, my lord, you had this direction was earlier also made, and we concised it. My lord, apologies, but that has not come up here.
ସେଟା କହିବେ ନା ଯୋଉ ଫାଇଲ କରିନି ବୋଲି ଆପଣ କହିଲେ affidavit ଫାଇଲ କରିଛି ବୋଲି.
Yes ma'am. That's all. And my lord, this is the.
ସେ କେବେ ଆସିବ ସେଟା? କେବେ ଆପଣ ସେଟାକୁ next week? Next week ରଖି ଦିଅନ୍ତୁ ପ୍ରେସର. ଆପଣଙ୍କ ନାଁଟା ହଉଛି Mr. K. Panda?
No, my lord. Dakshesh Darshan Naik, DD Naik.
Mr. Dakshesh Darshan Naik for the petitioner. The matter was passed over and is called again. The command learned counsel for the petitioner is heard. He refers to the order dated 732026 and submits that earlier affidavit dated North in 2026 was filed. Thereafter, the details of payments have been filed. Upon affidavit na memo na
with memo, my lord.
The details of payments have been filed with a memo, which may be brought on record. The matter shall be, as read for, the matter shall be listed in the recommencing author.
The concise formats were filed, my lord.
Fair enough, but yes, the problem is that.
Understood, my lord. I will follow up and.
ଆପଣ କୋଉ ତାରିଖ ଦିନ କେତେ ଦେଇଛନ୍ତି 3ଟା ଜିନିଷ ଦରକାର.
Yes ma'am.
ଅର୍ଡର ଡେଟ୍ ହେଲା ତାପରେ ଆମାଉଣ୍ଟ କେତେ?
Yes.
ଆଉ ଯଦି ଏରିୟର ପାର୍ଟ ରେ ବି ଆପଣ କହୁଛନ୍ତି କିଛିଟା ଦେଇଛନ୍ତି ସେତିକି ଲେଖିଦେବେ. ମାନେ ଡେଟ୍ ଅଫ ଆପ୍ଲିକେସନ ଏତେ.
Yes.
ଏତି ଆମାଉଣ୍ଟ ଦିଆହେଲା ଅମକ
in a tabular form.
ସେତିକି.
Understood, my lord. My lord, if I may I present you, this is the latest challan.
ଆପଣ ଫାଇଲ କରନ୍ତୁ.
Achha.
The learned counsel submits that he will file further details supported by memo, which shall be taken on record, scan copy be updated. Ebe je counter file kar diyo?
Yes, my lord. Immediately. Oblige, my lord.
Yes. Can you the name dedication of the type please? I'm sorry, I forgot your name. Apanaka nanda?
My lord, Shashank Shekhar Das.
Shashank Shekhar Das. Mr. Das, Mr. Palit will be able to join or he's absent?
My lord, he is on his legs.
Okay. Matter of time. ରଖିଥାନ୍ତୁ ପାଖରେ ଏବେ ଟିକେ I think ଚଲେଇଦେଲେ ହବ. Anything else, Mr. Lenka?
Special list item 1.
I think I covered it. Day before yesterday, I could not cover because time could not permit yesterday. ଆପଣ ଡେ ବିଫୋର ୟେଷ୍ଟରଡେ ସାଇଟ୍ କରିଥିଲେ ପାର୍ଟନରସିପ୍ ଆକ୍ଟ ସେକ୍ସନ
Partnership. 24, no. Worship. Section 18 and 19.
It is any Kali discussion. Day before yesterday I had cited 18. In 19 I got 24.
24.
I think that was the cover ହେଇଯାଇଛି ଆପଣ କଣ୍ଟ୍ରାକ୍ଟ ଆକ୍ଟ ରେ ଚାପ୍ଟର ଯୋଉଟା 189 ସେଟା ବୋଧେ
ସେଇଟା ଗୋଟେ
ଏଜେନ୍ସି ଚାପ୍ଟର 10 ଚାପ୍ଟର 10 ଏଜେନ୍ସି ରେ କୋଉଟା କରିଥିଲେ
229.
229
ଗୋଟେ NI Act ରେ my lord clearly ଦେଇଛି company means anybody corporate and includes a firm or other association of individuals. So here that the lessees, they are individual association of individuals.
You are saying that they are a partnership firm.
Yes.
So for that you did not go to negotiable instruments act.
Yes, negotiable.
Take your seat. ଆପଣ ସିଏ ବି କହୁଥିଲେ ବୋଧେ ସେଟା ସିଏ ଥିଲା ଆପଣ କହିଲେ କ୍ରିମିନାଲ ମ୍ୟାଟରଟା ବଡ ପଚାରିଥିଲେ କାଲିକି ସିଏ ବି ଥିଲା ନା ପ୍ରୋନାଉନ୍ସ ହେଇଥିଲା ସିଏ ବି ବୋଧେ ଆପଣଙ୍କ ଅଫିସ ଆପଣ ସ୍ଲିପରେ ଲେଖିଛନ୍ତି ସିଏ ବି ଦେଲେ ସେଟା ତାଙ୍କୁ ଦେଖି ସେ ଫାଇଲଟା ମଗାଏ ବୁଝିଲେ ତାହେଲେ ସେମ୍ ରେଟ୍ରେ ମୁଁ ତାଙ୍କୁ କହିଲି ସେ ବୁଝିପାରିଲା ଆପଣ ମତେ ପଚାରିଥିଲେ ମୋର ମନେ ଅଛି ମୁଁ କହିଲି ଯେ ନାଇଁ ଏଇଟା ପ୍ରୋନାଉନ୍ସ ହେଇଯାଇଛି ତାପରେ ତାଙ୍କ ନୋଟ ଦେଖିଲି ଲେଖା ହେଇଛି ସିଏ ବି ଆପଣ ସେଟା ପ୍ରୋନାଉନ୍ସ ବୋଲି କରିବାକୁ ପଡିବ ଆପଣଙ୍କୁ ଆପଣ ଯୋଉ ଡାଟା କମ୍ପ୍ୟୁଟର ନା କୋଉଥିରେ କରୁଛନ୍ତି ସେ ଯୋଉ କନେକ୍ଟେଡ ମ୍ୟାଟରରେ ଜଜମେଣ୍ଟ ତିନିଟା ଯୋଉଟା ଥିଲା କାଲି ଦେଇଥିଲି ସେ ଫାଇଲରେ ଅଛି ବୁଝିପାରୁଛନ୍ତି ମୁଁ ଯାହା କହୁଛି ଆଉ ତିନିଟା ମ୍ୟାଟର ଡିସ୍ପୋଜ ହେଇକି ଗୋଟେ ଜଜମେଣ୍ଟ ଅର୍ଡରଟା ଅଛି ସେ ଫାଇଲଟା ଭିତରେ ଥିବ କାଲି ଥିଲା ସେଟା ଫାଇଲଟା ଆଣୁ ସେପଟରେ ଥିବ ଆପଣ ମତେ ଏବେ ପଢେଇଲେ ସେପଟକୁ ପଠେଇଦେଲେ ଆଜ୍ଞା ସେଇଥିରେ ସେ କପିଟା ରଖା ହେଇଛି ଦେଖିଦଉଛି ଆପଣଙ୍କର ସବମିଶନ ଗୁଡାକ ମୁଁ ଯାହା କାଲି ରେକର୍ଡ କରିଛି ଜଷ୍ଟ ଆପଣଙ୍କୁ ଆଉଥରେ କହିଦେଉଛି is contended by the learned adjutant of the advocate. Notices have been issued to the power of attorney holder on behalf of the firm, all the lessees. Therefore, notice has to be treated to be sufficient. It refers to the lease deed form case dated 3/2/95 annexure C by 3. Submit that lease deed has been signed by the constituted attorney. Kanti ki Kanta Shret ko dekhi mane eta to correction hi nahi
On
Kanta
behalf-
Prasad bode amar eta Kanti ko deji Kanta Prasad H Pandya as power of attorney holder of Hargobind Pandya and others. For all the lessees on behalf of the governor of Odisha, of the state of Odisha, the collector producer has signed the deed. He refers to annexure D by 4 to the reply to the rejoinder filed by the state to submit that Devendra Hilji Pandya has signed on behalf of the lessees. He submits that sufficiency of notice on the lessee is achieved by serving the notice upon power of attorney holder Sri Devendra H. Pandya. To support his contentions regarding the implications of power of attorney being executed, having been over, correction to he to draft the learned AGA has relied upon the decision in state of Rajasthan versus Basant Nahata and Nagu Bhai Ammal versus Samarao 1996 AC 593. ଆପଣ ସେଇଟା ଦେଇଛନ୍ତି ଯୋଉଟା ଲିଷ୍ଟରେ 6 ଆଉ 7 6ଟା ହଉଛି ବସନ୍ତ ସମାରୋହ 2 ହଉଛି ବସନ୍ତ ନାଟ ଆଉ ନଗୁ ଭାଇ On being asked regarding execution of interpretation implication section 4 of the partnership act, the learned AGA submits that there can't be any second opinion on execution of execution of भूल word कौन है what a correction करे पड़ेगा execution कौन implication की interpretation हो section 4 but he relies on Ashutosh versus state of Rajasthan paragraph 12 and 13 quote था The learned AGA is apprised of the line of decision in which section 4 of the Indian Partnership Act has been interpreted. Two of them, Malabar Fisheries, out of AR 80 Supreme Court, 176, and Comptroller and Auditor General versus Complex Vadilal Mehta. The proposition of file ki nahi sita. Agar nahi. ଫାଇଲ ନାହିଁ ବୋଲି କହୁଛନ୍ତି ଆପଣଙ୍କ ପାଖରେ ଅଛି ଏଇଟା ଏଇଟା ଆପଣ ନୋଟ କରିକି ଆଉ ଏକ୍ସଟ୍ରା କପି ଅଛି ଆପଣଙ୍କ ପାଖରେ ନାଇଁ ଆଉ ଗୋଟେ ନେଇ ଆସିବେ ଏଇଟା ଆପଣ ପଠେଇକି ନେଇ ଆସୁନାହାନ୍ତି ଏଇଟା ଟିକେ ଆପଣ ଯାଇକି ନେଇ ଆସନ୍ତୁ ସେଟା କାହା କମ୍ପ୍ୟୁଟର ଦେଖିକି ଦିଅ ଯିଏ ବି ଥିବେ ସେ ଯାହା ନାଁ ଥିବ ଦେଖିକି କରିଦେବେ ଟିକେ ପଛରେ ନାଁ ଲେଖା ହୁଏ is submitted by the learned AGA that state has entered into lease agreement with one Sri Kanta Prasad Pandya by lease date dated 3/2/1995. He relies on additional affidavit annexure 3 by 3 filed by the state deputy director mines. The lease deed reflects thus. It is submitted by the learned AGA that the state has entered into agreement with the power of attorney holder on behalf of all the lessees on the face of anyway, so that's the conclusion. It is submitted by the learned AGA that the notice is to the farm which had been granted the mining lease. Repeat the notice is to the farm that has been granted mining lease. That आपनकर annexure कितने रेटा अच्छी से जो पेपर उड़ा कौन कले तादेर जो कागज उड़ा लगे थिले ऑडियंस स्लिप उड़ा को देखिए It refers to annexure A by 3. A by 3, आपका A by 3 जोड़े ताकर आउट अच्छे annexure सेट है, किंतु A by 3 रे रतन पंची.
by 3 का demand है.
हाँ. That is issued to the farm.
Yes, it is dependent.
D1548. Demand notice 2917.
Yes.
It is submitted that the notice to the lessees in terms of the section 24 of the Indian Partnership Act. Section 24 is reproduced.
Yes.
That is your submission. Our submission है the learned AG relies on additional affidavit related at the annexure C by 3 filed by the State Deputy Director. The list it reflects thus. Page 18 and 19 of the additional affidavit. Upon section rely question out 24 तो गला Partnership Act out कोटा section लिखो. $18.
18. Partner to be
18.
agent of the farm. So
2E. 2E.
2 is a definition.
Definition clause. Then 18.
18.
24. 24 already.
24 and 25.
24 and 25.
Yes.
A partnership राव किसी provision 80. ଆଉ କିଛି ରହିଲା
जो डेथ ऑफ पार्टनर ता जो सेक्शन 6 रे
6
सेते कहली if a partner dies his legal representative may be admitted to the new partnership by the surviving partners. Section 6 है. Here is the case that the Kanta Prasad died.
So the surviving partners have to take him.
Yes.
Section 6 quote है ना.
Yes. So your lordship can see the comment. Death of partner.
6 है ना. Mode of determining existence of partnership.
Yes, sir.
अच्छा.
In determining whether a group of persons is or is not a firm, or whether a person is or is not a partner in a firm, regard shall be had to the real relation between the parties as shown by all relevant facts taken together. The sharing profit of gross return, that is expansion, arising from property by persons holding a joint or common interest in that property does not itself make such persons partners. The receipt by a person of a share of the profit of a business or of a payment contingent upon the earnings of profits or varying with the profits earned by a business does not of itself make him a partner with the person carrying on the business, and in particular the receipt of such share or payment by a lender money so and so such. Then the comment you will also see third line, but if a partner dies, his legal representative may be admitted to the new partnership by surviving partners. The only question such case will be whether any share of profit received by him or partner belongs to him personally or to the estate which he represents. The answer will be inevitably depend on the facts and circumstances of the case. However, there can be no legal bar to a personal representative of the deceased partner being admitted to the partnership by surviving partners. If the personal representative of the deceased is also one of the surviving partners, he can agree to join the new partnership as a nominee of the legal heirs of the deceased partner, Commissioner of Income Tax. Here, my lord, all their legal heirs after the death of Kanta Prasad, his wife and children, other children, they have been included in the partnership.
In reference to section 6.
6. That has not been mentioned in that, but now they are his legal heirs are the partners.
Referring to section 6 code call, the land count relies on section 6 of the Binded Partnership Act 1932, which is reproduced within. In the context of the said section, it is submitted that the legal heirs of the deceased Sri Kantanganada?
Kanta Prasad.
Kanta.
Yes.
Hirji Pandya.
Kanta Prasad, Hirji Pandya. That is mother, wife and children.
Wife and children.
That is his wife and children have been have formed or what is the language you are using?
Have been admitted in the partnership.
Have been admitted in the partnership.
And also in profit sharing.
Also in the
profit sharing.
Also in the profit sharing.
Because if your lordship,
I think they are not disputing that.
The main dispute,
because unless they don't dispute, because if they dispute that, then they don't stand a chance as far as the lease is concerned. They say, yes, we are partners. They don't dispute that.
They say they are disputing the appointment of power of attorney.
No, not that.
They have challenged that.
No. They are saying that issuance of notice to the power of attorney holder is not notice to us.
One part.
To the lessees.
Yes.
That is the main thrust of
yes. One part.
So that is because if they will deny everything, they do not they do not dispute the ownership or other things, but they say notice. We cannot put these words to their mouth that they are denying the partnership, of course. We cannot. The reason being,
they have denied
they are saying that so जो अपना power of attorney holder, sufficiency of notice to power of attorney holder is there.
And appearance before the collector.
Yes, but that is that notice to the power of attorney holder, but somehow very peculiarly आपण भी सेटा stick करूछन. से तो कहउचंती जे तांकू देले हमकु नो. आपण ताकू तार रिप्लाई दउचंती तांकू देले तांको पे सफिशिएंट.
आमे कहउछु आमे फार्म को दो.
Reason being, तामाने मोर कहया कथा I am saying that surprisingly, तामाने आपण dispute भी करूनन जे तांको दिया ही बोली.
आमे कहउछु थ्रू फार्म.
आपण कहउछन जे तांकू से जो पावर ऑफ अटर्नी को दिया गया
दिया है बस.
तांकू दबा दरकार नै बेले आपण से कहू नांती से लैंग्वेज ता नाही सेठी. आपण कहउछन जे सी कहउचंती आमे पाइनु. आपण कहउचंती तांको आमे देनु.
इंडिविजुअली आमे पाइनु.
आमे तांको देनु आमे पार्टी दे.
Your lordship is absolutely right. Yes,
that is the bone of contention.
Yes.
That is how I was saying that if I am stopped there at that point, then there will be no effective adjudication of the matter. Because at this stage, liability has to be determined.
Yes.
So that is the reason, one of the reasons, principal reasons that I want that this matter has to be heard by the authority, taking all these things into consideration. Only quote कर देले. In the context of it is sentence complete है. Have been Partnership. Partnership one. Yes.
Because partnership arises from contract, not by status.
Right. That is how the concept is. But death of a partner, legal heirs do not get substituted.
Yes.
They have to be admitted.
And if you
And to that extent, factually, both of you agree. You say that yes, we have not served. They say we have not served. But you say service on the one is enough. They say service on one is not enough.
Yes. And if your lordship reminding the matter, only I pray, my lord, your lordship may target a debt.
से कहते मत 4 मास जगह 6 मास दियंतु which is reasonable. से जो 4 मासटा गोटे मु डायरेक्शन देइछि से कहते 6 मास दियंतु. Maybe he is on leave for 1 month that he said.
No,
but that is not part of this discussion. What he said मु रहिबिनी मते
because some of the
ना मु तो डिस्पोज कर देबे ना मु तो अपेक्षा करिबिनी छुट्टी सरला पर्यंत I'll be pronouncing. So say आपण को प्रीडिक्स गुडा को मु सिट पे से जजमेंट ता काढी छी. Just I will just now discuss with Ms. Pradhan commissions ଆପଣଙ୍କର ଗୁଡାକ. As I have discussed with Mr. ଆପଣଙ୍କର ये power of attorney act रे I think ଆପଣ ସେଟା साइड କରୁଛନ୍ତି but power of attorney they are not disputing. They have executed the power of attorney, it is their document.
Yes. But they say they for a limited purpose. They say, but we say no, subsequent power of attorney has given the details. What he will do, he will appear and communication, correspondence, everything is there.
Renewal of lease. That power of attorney is also.
In 2010 power of attorney for
It is also limited to.
no.
ଆପଣ power of attorney को कोटा
सेटा D/4 to our reply to regender.
Just one second. ଆପଣଙ୍କର 5 जोड़ा ତାଙ୍କର D/4 ସେଇଟା.
Is 2010.
ତାହେଲେ let me complete. Let your senior complete. I'll come back to it. Simply facts. I'm not facts and salient the points. ଆପଣ Mr. Lenka annexer D by
and annexer D/4 to my reply to the regender. This power of attorney executed in the year 2012. And what my learned friend is
2012 ଆପଣ
yes.
କହିବା କଥା ଯେ this gives
more.
So according to this power of attorney the notice should be sufficient.
Yes. But annexer 5 to the writ petition, another power of attorney, same Pandya, D. Pandya. That was for limited purpose.
Annexer 5
to the
limited approach. You are distinguishing annexer 5 and D/4.
Yes.
That annexer 5 is limited. D/4 for every act.
Yes. From 1 to your lordship.
AGM submission. So what I para kurte. Now it is madman. So there is a theory of writing of judgment. So they say madman, engineer and sculptor. You start with as a madman, you gather everything. Then you have a design, engineer. Then finally sculpting is giving the shape. Annexer, the learned AG refers to annexer 5 of the writ application to submit that the said power of attorney is limited in language, and the subsequent power of attorney as that annexer D/4 into bracket
reply to
annexed to the reply to the regender bracket closed is wider in ambit. Which goes to show that notice to the power of attorney holder would be sufficient notice to the lessees. Regarding the contention of the petitioners that the power of attorney Is Pradhan registered quota, unregistered quota? No, it is a unregistered.
The second one is registered, the 2012, but the first one is only notarized.
No. Yes. That,
Regarding the submission that the 2010, the POA, power of attorney, POA short code, P capital of POA executed in 2010 is not registered and notarized. The Lord DGA in response refers to the decision of the Honorable Apex Court and relies on the same.
that is state of Rajasthan versus.
Syed Abdul Khader versus Rami Reddy. Yes. Para 17. Takara citation 1.
Yes.
A list 1 watch.
And also 2 also.
Gote diyo.
And
Vasant Nahata is already cited.
And I'll place section 84 of the Bharatiya Sakhya Adhiniyam corresponding to 84 of Indian Evidence Act. Section 81. Presumption as to power of attorney. Presumption as to power of attorney. The court shall presume that every document purporting to be a power of attorney and to have been executed before the authenticated by a notary public. Section 85 of the Bharatiya Sakhya and corresponding in Indian Evidence 84. I'm reading one second. The court shall presume that every document purporting.
He refers to the section 85 of the Bharatiya Sakhya Adhiniyam corresponding to section 85 of the Indian Evidence Act.
84.
84 of the Indian Evidence Act.
No, sorry. I'm sorry. 84 of Bharatiya Sakhya, 85.
84 of the Bharatiya Sakhya Adhiniyam, BSA. 85 of Indian Evidence Act. To submit that, even power of attorney, notarized power of attorney can be relied upon.
Yes.
By the court. Can be relied upon. Stop.
That language is was so executed and authenticated. That's not necessarily for register. When there is a matter, when there is a sale deed or alienation of property, then that is under section under 1908 Act, Registration Act, that is matter. But here is
Indian Contract Act. Contract upper 229 ko chalo.
229.
Indian Contract Act section 229. The relies on the provision contract in Indian Contract Act section 229.
And also
which provides thus.
Yes. To that effect,
Submits that
citation there.
the agent in the case at hand, the power of attorney holder is the agent, and notice to the agent is sufficient notice to the principal.
Citation at serial number 5 to that effect. 2017 SCC online Madras.
Citation of serial number 5. relies on decision of the Madras High Court. Serial number 5. Yes, please.
Good line put.
Yes.
One. Thus, notice or intimation given to an agent or knowledge of any fact material to such transaction acquired by the agent binds the principal.
No, that is, that is obvious, Mr. Venkata. Here, but by answering that, this court will not answer the issue. That is the problem. Because you are saying that he is the agent, they are saying they are not the agent. That is the problem. Because even the power of attorney, everything is not disputed. Nothing is disputed actually to that extent. Sufficiency, even they know that they say that it has been served on the power of attorney holder. They don't deny that also.
Now, I think your lordship has gone to the root in all the actions. And after finalizing, cream will come out.
No, because the difficulty would be that if I say either way, it is not going to end there.
No, your lordship is
because if in the kind of, because everywhere they have entered, you have signed that they mentioning them as lessee. That is your document. The document which you have relied on, it is, you have mentioned them 1 to 10 as lessee.
But the firm name also is there.
So that is the problem now. And this proceeding is contemplated. What you are now challenging is OPDR. It is not the mining. That is another problem. So in OPDR, the stand and the notice stand, they are different. And this, if it goes to the stage of notice, it will be the stage of notice by the mining authority. So that
requisition. Yes. Then thereafter collector. Your lordship, no problem. But all these things your lordship discuss.
Yes. Yes, Mr. Pradhan.
Contention, my learned counsel's contention that the power of attorney holder, this notice to the power of attorney holder is sufficient. My only answer to his contention is that the power of attorney holder, which he is relying on, it is very specific. It is only for the purpose of renewal of lease. Mr. Devendra Viji Pandya was appointed the power of attorney holder for.
Please refer to that.
Annexure 5.
Power of attorney holder.
Devendra Viji.
Apno 2012 na 2012.
2012. Also relying on 2012 power of attorney document. There we are up to page 11. Up here, now that
the purpose of renewal.
We do not dispute that.
Renewal of
It is submitted by the counsel for the petitioner that the power of attorney executed in 2010 as well as 2012 both are for the purpose of entering into agreement with the state regarding renewal of the mining lease. They cannot be interpreted to be anything more than that is reflected in the power of attorney itself. Yes,
No.
upon देखुचन सेटा कोर्ट पेज देखा
No matter.
That is her content.
Sorry, 2010. Let me record clear.
I have noted. Upon कुचन
2010 is specific.
12 is not specific. See,
12 is more.
See that says that yes, 2012 also is specific. That is her contention. But since he is submitting, I mean, as per your submission, it looks like rejoinder. But she was not hard, as I have noted your submissions. Yes, please go to the page.
So page 11 of the reply to the rejoinder dated 18/3/2026. And whereas,
Page 11 you are saying, reply to rejoinder on behalf of opposite parties.
2026.
annexure hobo C/4 na code
D/4.
D/4. Just one second. Yes, D/4. Just one second, I have to note it. Reply to agenda dated
18/3/2026.
ଆପଣଙ୍କ affidavit ଟା 18/3/26. ତାଙ୍କ affidavit 18/3/26. ହଁ. D/4. You are referring to
Power of attorney, second.
whereas?
Page 11.
Huh?
Whereas the said Devendra Prasad E.G. Pandey is one of the partner of our bid, hereby willing to undertake the responsibilities hereafter vested to him. Now therefore, by these presents, that we above named recipients who have authorized and empowered said Devendra Prasad E.G. Pandey as our true and lawful for us on behalf to do the following acts, deeds and things, to do the following acts, deeds and things. That is to say, to appear before competent mining authorities or departments, IBM authority, concerned DDM, mining office, forest department, sales tax, income tax department, director of mines, Odisha, Bhubaneswar, and or any other authority, office of government, state and central, and to deal all official dealing stroke correspondence in such office in intending to obtaining any permissions, mining deeds, renewal of mining deeds and other licenses, sales tax clearance, mining due clearance certificates, and any other permissions, license, approval, etc. for on our behalf. Further, Your Lordship, sign and swear affidavit, write petition, wakalatnama, and any kind documents or all other necessary documents, papers, and file them before such competent office authority, including the aforesaid office, that is mining authority, office, IBM, forest department, sales tax, income tax department, director of mines, Odisha, Bhubaneswar, mines and seals department, government of India, etc. In intending to obtaining stroke renewal of mining lease, any other approval, permission, clearance, etc. respectively for and on our behalf. Your Lordship, it's clear that all these acts are for renewal of mining lease. And all those clearances, those were all consequential and incidental acts as to the renewal of mining lease. He was appointed as the power of attorney holder. Deal.
There are more points, sir, ma'am.
Your Lordship,
Let it be complete.
to deal all official correspondence, communication in such office of state and central government for aforesaid facts and purposes as per requirement for and on behalf our behalf. Your Lordship,
Then to take back.
To take back any documents, permission, renewal of mining lease, permission, license, sales, tax clearance certificate, income tax, up-to-date return file, MPCC clearance from forest department, all such requirements, documents, permission, license, etc. for and on behalf in intending to business relation and necessity and on behalf of Jajan Iron and Manganese Mines. To appoint any advocate, pleader, and or legal practitioner and compound any case as pending against the said above being firm as arise in future to represent us before such office, authority, both competent authority, department of government, state and central, as it might require for the said facts and purposes.
So you are saying that no, this was discussed actually. In fact, I had asked that anything is there. You are saying that it does not contain receiving notice. Mr. Palit, actually, since though you have not been heard elaborately of late, so after Mr. Lenka has completed, his point is that Mr. Lenka's contention is that 2010 power of attorney was specific. 2012 power of attorney, annexure D/4, is all encompassing as far as the farm is concerned. So notice to the farm is in tune with that power of attorney. I mean, notice to the power of attorney is in tune with the power he holds.
Yes.
So Ms. Pradhan she has raised the contention that both 10 and 12 are limited.
Limited. For the purpose of renewal.
Perhaps Mr. Lenka says that yes, 10 can be limited, but 12 is not. That is his contention. Is not it? Yes.
Not only
Serial
that,
number 3 and 6 is clear.
not only that,
She has read 3, 6.
Yes. Before the authority.
She says for the aforesaid facts. 3 she is saying so and so deal with all official correspondence for the aforesaid facts and purposes as per a requirement for and on our behalf. So it is not beyond that.
renewal. 2 says renewal. 2
That she has placed. 2, 3
confines
she has-
it to renewal. So this cannot be given a wider, and also page 70 of the writ application, the covenant in the lease.
So Mr. Lenka is
There's a
relying on
specific provision.
Mr. Lenka is relying on 2 and 3 and 6.
3 and
3 and 6 of 2000.
We are reading the whole document together. I'm
And
reading the whole document together, 1 and 2. Just, sir, put him. Sir, page 70. Lordship may kindly come to page 70.
Same document, na other document.
No, I mean lease, it's all the document. Page 70 is the renewal detail. 1995 renewal detail. That's the foundation.
Annexure 1 to the writ petition.
That's the document. Annexure 1. Page 70 the annexure notices. Every notice by these presents.
Just 1 second. I should scroll actually. More book packet page
I
get there. I think this we read on the past day.
Yes. That is the traction actually.
Page 70. No. So as a lawyer, Mr. Lenka has done his best because I have again and again drawn his attention.
All in common.
That the paragraph 1, you have signed the lease and you have mentioned them as to be the lessees.
That.
So now on this, in one hand you are saying they are the lessees, and the other hand you are saying that since they are a partnership firm, and one of the lessees is a partner with power of attorney holder, that is sufficient.
That's what his contention.
That is the yes.
And also the notice. Lordship may kindly appreciate.
70 notice apana kouchanti.
Notice every notice.
Notice clause.
By these presents required to be given to the lessees shall be given in writing to such person resident on the said lease as the lessees may appoint for the purpose of receiving the notice, and if there shall have no such appointment, then every such notice shall be sent to the lessee by registered post addressed to the lessees at the address mentioned in this lease at such other addresses in India as the lessees may from time to time in writing to the state government. So, Jadi, along with the power of attorney, they could, along with the company, they would have also noticed the lessees. They would have complied with all the requirements.
You are following Rajasthan cited by Mr. Lenka.
Again?
Nahata. Yesterday, Mr. Lenka cited that decision, Nahata, where along with the company, the parties were noticed.
That was the crucial distinction. But
That is Asutosh.
Asutosh.
So that can be the only logical extension. Meaning is that the covenant to harmoniously read them together.
No, I mean, obviously, Mr. Lenka is not disputing the listing.
It is.
That is how perhaps his approach is that to highlight the second power of attorney to be a power of attorney, which gives more power to the power of attorney holder to receive notice.
But all in context
of... we have discussed this, that everywhere the lessee has been very clearly mentioned, signed by the state and the lessees.
And notice provision
And maybe it is signed by one of the person on behalf of all
on
the
behalf
lessee.
for convenience.
But
that does not.
Everywhere it is mentioned as the lessee.
Liability will devolve on all. So if liability will devolve on all, naturally notice has to go to each one, and each person holds a separate portion. And also in the covenant, notice just one more proposition just to supplement and add to your lordship's manner of discussion, if your lordship accepts subject to. It is a severable hamta from some way. The lease deed is to read together. With the
lease deed covenants are not severable.
That's the point. That is the fundamental point. If the covenants are not severable, then notice is an essential part. So only way they could harmoniously construe everything together is to say to that judgment would be the in line of that judgment. Even otherwise also.
That judgment is actually they had
execution of a decree.
They are party to the suit.
Suit appear
somebody, some lawyer has advised that he now denying the execution.
So, but they are
court will obviously say that you are party to the suit. How can you deny that there is a decree against you are a judgment debtor?
Yes, the suit was correctly structured.
Yes.
So company and this thing and the so that.
So the notice part, I would like to
yes
read in my way.
Yes.
Your lordship, every notice.
Let him complete. You just note down because he'll be again breaking and because I'll also be concluding his submissions today. Just hold it. You will have a right. No difficulty. I don't think you'll mind that.
ଖାଲି ସେ ଗୋଟେ ପାର୍ଟ ଛାଡି ଦେଇଗଲେ ମାନେ ସେଇଟା ଆଉ କିଛି ନାହିଁ
जस्ट आपण नोट कर दीजिए ये ଗୋଟେ फ्लैग मार फ्लैग दरकार ଯଦି नोट नहीं है actually one of the 2-3 courts they were liberal with us providing flag court master like Mr. Barik in the morning they will give us the flags because you said that you are using so many flags how from we will get
the power of attorney in 12 Juta Emane they have signed that
D/4
session again D/4 This D/4 what is this? Lakshmi kindly did this, whereas we the above.
You are reading D/4?
Yes, page 10.
There are extra D/4?
Page 10, and internal page 4 of the D. We the above named executants being partners of the said firm, so and so judging are always busy in business concerns. Hence, we are unable to take all the responsibilities that is to unable to appear before the competent authority of government, state and central, including concerns mining, officer, DDM, sales, income tax department, IBM, authority, forest department, director of mines, Orissa, Bhubaneswar, as well as before other such competent authorities, court, government, state and central, as per requirement to obtaining renewal of license, approval, clearance certificate, and such other permission or permissions, etc., for and on behalf. So this was confined to that kind of an activity. One. This is after the mines have started operating, and after operating the mines had ceased, and then Supreme Court litigation and a demand notice comes. Saddling demand and with the perspective of recovery under OPDR case. That would be a completely separate. OPDR proceeding would be a separate proceeding. That demand would be something not contemplated under this. Now therefore, because some of them might have interchanged their shares. In the meantime, some of them must have sold out. So that opportunity to deny should be there. And or others might say, we'll bear this gentleman's burden, so I will clear the rest. So all those defenses could have been given. And that is besides the point that we would be in a position to raise other pleas in objecting to the demand. However slim that chance is, that chance should be given. Now, therefore, by these covenants, we, the above named executants here to have authorized and empowered the said Devendra Prasad Hirji Pandya as our true and lawful attorney for and on our behalf to do the following acts, deeds and things. That is to say, to appear before the competent mining authority, department, IBM authority, concerned DDM, mining office, forest department, sales tax or income tax department, director of mines, Odisha, Bhubaneswar, and all other authorities, office of government, state or central, and to deal with official dealings, correspondences in such office as intending to obtain any permission, mining lease, intending to obtain any permission, mining lease, renewal of mining lease and other licenses, sales tax clearance, mining lease dues, clearance certificate or other permission, license, approval, etc. for and on our behalf. So it is basically to do the day-to-day activities relating to renewal or obtaining of the mining lease. So this was not in contemplation. One. To sign, swear, affidavit, write petition, wakalatnama and kind petition, documents, so and so other necessary documents, however, to file before such competent office authority, including aforesaid office, department, mining office, IBM, forest department, sales tax, income tax, director of mines, Odisha, Bhubaneswar, mining department, government of India, etc. in intending to obtaining renewal of mining lease, any other approval, permission, clearance, etc., respectively or for and on our behalf. So always the accent is on obtaining renewal, mining lease or renewal, or there may be some litigation relating to the mining lease also. So all those things, suddenly an affidavit may require to be filed. Your Lordship knows that this is a very complicated business also, mining. So for that we appoint somebody. That does not mean that I have waived my right to receive a notice of demand to deal, and this document has been construed in that light, to deals with all official correspondence communications in such office and our state or other for the aforesaid facts and purposes as per requirement for and on our behalf. And then, my lord, to take back documents, permissions, renewal of mining lease, permission, license, sales tax, income tax, date return, MMDC, clearance from the forest department or such other requirements, documents, permission, license for and on our behalf, intending to business relationships and necessity for and on behalf of the said judging iron and manganese mines, to appoint advocate, pleader, and all legal practitioners, and to compound any case as pending against the above named firm and not arise in future. To represent us before us in such offices, authority, court, competent authority, department of government, state, as and when required for the said and above facts. In generally to do all acts and things as will be done and executed, performed by the attorney holder, as well done by us. And that, so therefore, this can be given an extended meaning for my lords issuing for bypassing the necessity of giving me a notice, demand notice. Because admittedly, the original lessee in whose name the certificate has been issued is dead. And the lease has been renewed in the name of the lessees in person. Renewal has been done in person. And my lords, as your lordship knows, in a lease deed, the covenants would guide the intention of the lease. And here the covenants clearly speak of no. And this notice, my lords, is normally
Page
notice at page 70.
70 notice.
7. That says clause 7, covenant 7. Every notice.
You are saying covenant.
Covenant.
Acha.
Clause.
Covenant in the clause, yes.
Clause.
Covenant clause.
Covenant.
Right.
Covenant clause, I think.
Right. Covenant
very
in
interchangeable.
the covenant in the deed.
Covenant is the deed. Covenant is this is the clause of the covenant. Every notice by these presents required to be given to lessees shall be given in writing to such person resident of the said lands as the lessee may appoint for the purpose of receiving such notices, and if there have been no such appointment, then every such notice shall be sent to the lessee by registered post addressed to the lessees at the addresses recorded. So this, as your lordship, my lords, I would go with the interpretation that for receiving notice other than renewal, there has to be some specific appointment in the power of attorney, some specific requirement.
Yes.
Could you
get on hand any decision that a partnership firm can appoint a power of attorney holder, and what can be the possibilities? So anyway, I just because that I have asked Mr. Lenka also, that I am asking you. But you are relying on any decisions?
Decision. I'll just show your lordship one more thing.
No, you carry on. You carry on your own.
Here appeared on his behalf. Let's see. Let's see. This Vakalatnama, your lordship, may kindly come to B/4. That is what they are relying on. In the counter affidavit.
Counter B/4.
B/4. They have filed the Vakalat. Devendra Prasad Hirji Lessee. He describes himself as a lessee. And he has appeared on his own behalf before the collector.
So, so what is their take on this? Their contention on
this? Their contention, this is sufficient. Our contention is this is not sufficient because he has appeared for himself.
On the face of it, you are saying
on the face
of it is he describes him not as a POA, but as a lessee.
As a lessee. There was no power given. Vakalat is also a power. No such document has been filed along with the power of attorney to give him. Power of attorney itself has not been filed before the collector. Even the power of attorney has not been recorded in the order.
Power of attorney file करने sorry था ना कोई point और arise करना था.
Order में record है नहीं खाली वकालत नामा record है.
ये करनी था ते ताले all this what you call breaking of head.
Inquiry sorry. So that's why my lords, again I would react.
That is what makes the law interesting.
Again?
ये सब जिनसे है collector का ये उनके बस में नहीं है इतने जिनसे भाविया पाई
नाम सी कुछ young IAS officers
समस्त वकील है क्यों है
आया नुआ young fresh IAS officers fresh from the academy they come and take charge as collectors. That experience,
even experienced persons, they realize they gradually mellow down and they realize that it is an enormous task.
I would
they pay a lot of respect to lawyers actually.
I would submit some experienced OS officers are far better. Well, I've had much experience working with them. Some of them. So, and basic principle, my lords, if there is a demand of this level,
and he has not executed. Acha, you are saying that you are saying he has executed as a lessee. Okay.
As a lessee.
The last line. Signature of the executant, lessee, jajang.
Bas, that's all.
Acha.
Power of attorney भी करेंगे.
Describes as lessee.
Lessee. The collector. So notice was also served.
So that would lead to a situation where notice is also not sufficient otherwise.
On the list. That's my submission, that we have not been noted.
So in fact, I will not go into expansive discussion because the submissions are made, so I am recording it. Because at least both the sides are more, so Mr. Lenka should be satisfied that he has whatever he has submitted, that is being recorded. To what extent I will go in deciding that this legal concepts, because I think the right time has not come.
Let there be thrashed out, factually let it be
because that will be against, that will not be, I will say, not in the interest of both the parties.
No. If it's an open remand, my lords, I agree with your lordship. If it's an open remand, let us fight the battle there. And my only prayer was, I will only pray for you. No,
I see, he has discussed that.
Has he agreed? 6 ମାସ ଟିକେ କରିଦବ 4 ମାସ ଜାଗାରେ ଆର ଗୋଟେ 4 ମାସରେ 6 ମାସ କରିଦବ
ସେ କହୁଥିଲେ ଯେ ଆପଣ 4 ମାସ ଦେଇଥିଲେ ସେ ମୁଁ କହିଲି yesterday it was discussed that since he will remain absent
ମୁଁ ଟିକେ ଆସିକି ଲେଖିବି
for 1.5 months, so that please may be considered. So 4 plus 1.5 becomes 6 ମାନେ 5.5
6
yes but ଲେଖା 70 ରେ ଆପଣ ଗୋଟେ କଣ କହୁଛନ୍ତି covenant 70
yes right
page ଟା ଖେଳ କୋଉ page ରେ ଅଛି page 70 ରେ जो covenant ଅଛି
yes I'll go there my learned senior he has said that renewal of the
से जो
license
जोटा पढुथिले
notice
yes
अपन लीज डीड पढुथिले जोटा
lease deed
specific authorization যদি থিব to receive notice then it can be waived.
My learned senior submitted before your lordship that the renewal of mining lease, that is annexure 1 to the revision and annexure
lease
that is
ଆପଣ କୋଉ ପେଜ ରେ ଅଛନ୍ତି
ମୁଁ ଯାଉ ସେଠିକି so renewal, my submission is that a renewal has been made in the name of the farm, that is annexure, your lordship may see annexure B/3, page 16 to my additional affidavit, not in the name of the lessee.
B/3.
Yes, page 16.
Okay.
So
B/3 कहले ना?
Yes. Page 16.
1/6.
Yes. In my additional affidavit. That's the
just one sir. Yes.
Paragraph 2 and 3. Whereas the minerals in the land in respect of which the second renewal of mining lease.
What is this B/3? What is this document?
That is the grant of renewal of mining lease.
Proceeding.
Yes. After their application, that is the final order passed by the government. Whereas the mineral in the land in respect of which the second renewal of mining lease has been applied for belongs to the government and the land is at their disposal. Whereas the applicant being a partnership firm registered in India, whereas the applicant by themselves or with any person joint in interest with them do not in respect of iron and manganese group. So my submission is, my lord, the renewal has been done in the name of the firm first. Second, my lord, your lordship, kindly come to D/4.
No, so what turns on that? Suppose let us accept that the renewal has been done in the name of the
No, not in the name of lessee, in the farm.
farm.
Yes.
So,
I
do you mean to say that since the renewal has been done, because we have to discuss what turns on that.
yes, I want to discuss
This is now in the name of the farm.
farm. It's a partnership farm, specifically mentioned.
To say that the members of partnership or the lessees are not to be noticed. Is it your purpose?
No, I'm not there. I'm not concluded. I'm not there. Whether notice has been sufficient or not, that part is come. Then your lordship may kindly come to D by 4. Only just D by 4.
D by 4 in
D by 4
problem.
D by 4 in
reply to region.
reply to region.
Okay. ଆପଣ ତାକୁ ABCD continuous କରିଥାନ୍ତେ.
D by 4. That is the power of attorney. Page, you know, page 12, straight to page 12. Just now my land senior placed.
Yes. 7 ରୁ ଆରମ୍ଭ ହେଇଛି. Power of attorney.
Power of attorney, 7 no.
7 D by 4.
Yes. 7 to 32.
I'm there. I got it.
Your lordship may kindly come to page 12.
Yes.
My land senior has placed 3. I am not again repeating. That is to deal all official correspondence communication in such office of the state and central government for the aforesaid facts and purposes as per requirement for and on our behalf. Then 4, to take back any document, permission, renewal of mining, permission, license, sales tax, clearance.
No, what actually, Mr. Lenka.
Then 5 is important, man. 5.
No.
5.
Yes.
My land senior skipped that.
Correct. No. He has not skipped actually. What he's saying, just start from 7.
Yes.
7 to the 7.
Yes, sir.
ତାପରେ ଦେଖନ୍ତୁ ଆପଣ 7 ରୁ 9 ଆପଣଙ୍କର ପାର୍ଟି ମାନେ ରହିଲେ.
ଆଜ୍ଞା.
ହେଲା 9 ଜଣ ହେଲେ
lessee partner.
ସେ ଲେଖିଲେ do hereby not last word ଟା ପଢନ୍ତୁ. 9 ରେ just last ଗୋଟେ type
all or any of the following acts and deeds.
ସେଇଟା ମୁଁ ଯାଇନି. Hinduism do hereby constitute, nominate, appoint one Sri Devendra Prasad Hirji Pandya as one of the party who is one of the party. 10 ରେ ପାଇବେ.
Constitute, nominate and appoint to one Sri Devendra Pandya.
ତାପରେ ସେଟା ତାଙ୍କ description ରେ ଛାଡି ଦିଅନ୍ତୁ.
Yes.
କିଛି ନାହିଁ.
As our true and not.
ନା 10 ରେ ଅଛି ଦେଖନ୍ତୁ.
ନା ସେଇ ତ ଲାଷ୍ଟ ଅଛି ବଟମ ରେ ସେଇ ପାରାର.
ମୁଁ ସେଟା ଆପଣଙ୍କୁ କହିଲି. Do hereby constitute, nominate and appoint to one ଦେବେନ୍ଦ୍ର ଯୋଉଠି ପାଇଲେ internal page 4 just two lines ଦେଖନ୍ତୁ. 3 lines rather.
Yes.
2 line no 3 line. Who is one of the party / partner of above named firm as our true and lawful attorney holder for us.
Yes, sir.
And on or our behalf.
Yes. To do any.
So here also they narrate Devendra as their one of the partners of the firm.
Yes.
Our behalf to do any or all or following acts, deeds and
things.
So now please mark city farm. What?
Farmer.
9.
Yes, named farm. Partner of above named farm.
ତା ପରଟା
as our two
our ଆପଣ ସେଟାକୁ ପଢୁଛନ୍ତି as farms. ସେ 9ଟା ଲୋକଙ୍କର ଡେସ୍କ୍ରିପସନ ହେଲା our.
Yes.
ସେ ସେଠି ଲେଖି ନାହାନ୍ତି that he is the power of attorney holder of the farm. What is not there.
Yes.
So ସେଟା
internal page 4 ଅଛି ବା farm.
ଶୁଣନ୍ତୁ ସେଟା ସେଇଟା ଆପଣ ଯେତେବେଳେ ଏବେ ପଢୁଛନ୍ତି
farm ଅଛି ନା.
So he farm ନାହିଁ.
ଅଛି. I'm reading. I'm reading the full. Sri Devendra Pandya Hijri Pandya, aged about so and so, resident of so and so, who is
Our it should have been as its true and lawful attorney.
who is, your lordship may say, who is,
Our or its, our to its.
See, in fact, Devendra is a partner. Devendra, who is mane Devendra chhad diyo.
who is one of the partners?
Address ta chhad diyo. Apna address ta सब पढ़ो.
Yes, who is?
Who ta Devendra कर दियो. Auri simple लिखियो.
Devendra
is one of the partner of above named farm. आज आवार न करी कि सेटा either ही था farm ही था or its ही था. See its कहउचंती.
Even if our is not there, it is clearly the expression is clearly.
से वाट नहीं है क्या?
नहीं जे above named farm means.
नहीं से पार्ट तो से भी सेटा मिस्टर पालित पढ़िला बेले सेटा पढ़ी नथिले. एक्चुअली सेटा मिस प्रधान पढुतले. तापर देखंतु to do any or all of the following acts, deeds and things. That is highlighting.
Yes.
Any act is as listed. So सेटा भी आपण भी हाइलाइट करूछन. बुझिले कि? 2 और 6 आपणकर से पढुछन सब गुडा को कहउछन जे 2 even if 2 and 6 does not say that he will receive notice on behalf of us.
That
we have not the actually he used a better language actually. Let us do justice to his language. We have not never waived our right to issue notice, receive notice. That is his language. I have noted that. Not waived right to receive notice or bypassing the necessity of giving notice. That is his argument.
So
आपण 70 रे आ गोटे कोन देखियो सो एनीवे आपण एटा कंप्लीट करंतु जरा सा आपण आसंतु no please don't get detain yourself effort से ढाव पड़िबो.
So 3 I am not placing, serial number 3, that is at page 12, already placed twice.
आपण 2 कहिसंती तो आपण को 2 और 6 I have noted.
Then 3
and 6 na 2 and 6.
I am relying the one to all. I am relying all the provisions at serial number 1 to 6.
What question? 1 to 6 will lead to a conclusion that he can receive notice.
Yes,
that is your submission.
Notice part mu jaine. Only if 5:30 ke elaborate karibi.
Notice the sir covenant mu kohni. There is a confusion actually. Je 2-3 thara heilani. Apanakara lease deed re gote notice covenant achi. 70 page re.
Yes.
So seta gote jinso. Seta to gote katha. But apanakara main thrust of argument, both of you, is that because everything turns on the power of attorney. Your case is that power of attorney itself discloses, or power of attorney is sufficient to show that he can receive notice on behalf of the lessees or the farm.
Yes.
But I have noted that.
Yes.
As I was reading.
Yes, that is fine.
They are saying that power of attorney does not authorize him to receive notice on our behalf.
Yes.
He is receiving a notice on his behalf is fine. And we have not waived our right to receive notice by giving it to.
He is saying
that is their contention. Yes.
But your lordship may kindly see the serial number 5 of that power of attorney, page 13.
Yes.
Okay. To appoint any advocate.
Yes.
Pleader and or legal practitioners, and to compound any case as pending against the said above named firm and oblique or as arises in future. What I humbly submit before my lord.
The problem is that
here, after he got the notice from the collector, the certificate officer, he appointed one Chaturbhuja Rana as advocate, and regularly they appeared before and also filed the WS there.
So that is a two-edged sword. Interestingly, before collector, he has himself written that lessee.
No doubt he is a lessee.
Yes. So problem which is since you are saying that he is a lessee and also a power of attorney, that is the problem. So he cannot write as a power of attorney holder from so and so. He could have. He has not written that. He has not written that. Maybe in hindsight now they are thinking that way and rethinking. See, when he appeared, he has very clearly said that so and so.
Let's see. Let's see what he has not mentioned the farm's name or on the.
I mean, no, ଆପଣଙ୍କର ତଳେ ଯୋଉ ଷ୍ଟାମ୍ପ ବଢାଇଛି ଯୋଉଟା ଅଛି ତଳେ ଦସ୍ତଖତ ଏବଂ ଉପରେ ପୁରାଟା ପଢୁଥିଲି actually. କୋଉଠି ସେଟା ସେ ଲେଖିନି. Right. Vaklatnamar he has not written.
Then your lordship may kindly come to that agreement 67. Notice. Annexer. Mine is annexer C/3. Yes, C/3. And annexer 1 to the requisition. Just now my 7.
C/3.
Yes, 7. Notice. Every notice by these presents required to be given to lessees shall be given in writing to such person.
Paste out the
Page 67.
Just once.
C/3, 67. Additional.
Yes.
Yes. Every notice by these presents required to be given to lessee shall be given in writing to such person resident on the said lands as the lessee may appoint for the purpose of receiving such notices. And if there shall have been no such appointment, then every such notice shall be sent to the lessee by registered post, addressed to the lessee at the address recorded in the lease or at such address in India as the lessees may from time to time in writing to the state government designate for the receipt of the notices, and every such service shall be deemed to be proper and valid service upon the lessees and shall not be questioned or challenged by them.
Correct. But
so here they have Devendra Pandya has been
actually this is the most difficult proposition you are advancing, because they say we have never appointed.
Never appointed.
They
are disputing the power of attorney.
No, notice. They are again. So that is the short point.
They say
no,
but they have signed that.
In fact, that is how you are also struggling to find out where they have appointed to receive notice. This 7 we considered on the first day actually. If you remember, we were reading this.
Yes.
So they are contention. Since you are, because you are also you have not shown anything, Mr. Lenk. I have noted everything.
Yes.
In your counter, go through your counter, all annexers, 3 you have filed, additional filed, or reply to rejoinder filed. Counter, he has filed rejoinder. Nowhere you have said that he has been authorized
to receive notice.
No, 7. ଆପଣ 7 ରେ ଯୋଉ ନୋଟିସ୍ ପାଇବେ ସେ ଆପଣ ସେଥିରେ anyway ଆପଣ ସେଟା ତ ହେଇନି, ସେଟା ବର୍ତ୍ତମାନ କିଛି କରିକି ଲାଭ ନାହିଁ.
But my submission before all in other way.
ସେଥିପାଇଁ ଆପଣ କହୁଛନ୍ତି to go out of that situation. You are saying that power of attorney of 2012 or 10 implies that he can receive notice. But
and also
so I asked, so that is the reason when yesterday you were mentioning section 24 notice. 24, you remember 24 in?
Power of attorney.
Partnership Act.
Yes.
So kindly show me the section 24 notice. Just look at again what you showed to me. Upon notice देखो
yes.
2/17 F/3.
Yes. Effect of notice to acting partner.
So in response to we were discussing, because it is factual, just now go to page 78 of your additional affidavit. This we have yesterday elaborated on this.
Yeah,
so kindly just look at 70. So I asked you that if there is a section 24, so then kindly show that notice. The notice you are showing is page 78, annexer F/3. Just look at F/3.
Demand notice.
Yes.
That is F by 3, yes.
Yes. So look at who it is addressed.
To the farm.
Yes.
Everywhere the farm.
So now what is, there is a problem. If you are proceeding on the basis of somebody receiving notice on behalf of the farm, he is to be noticed.
Yes.
XYZ on behalf of so and so farm. Fair enough. But in the notice itself also, we have not written the name of XYZ.
The farm. Because
You have written the farm.
because the renewal has been granted by the state government in the name of the farm.
Correct. So maybe I think that is correct. Because if you would have issued notice by XYZ when XYZ not has been appointed in terms of the clause 7.
Yes.
7 is something like your 24. 7 ର ଯଦି ଆପଣ ଲାଙ୍ଗୁଏଜ ଦେଖିବେ ଯୋଉଟା ଆପଣ ପେଜ 70 ପଢୁଥିଲେ
ସେଥିରେ ଗୋଟେ there is a bar to ଏ ଯୋଉ legal hair କୁ ନବା ପାଇଁ ଯୋଉ କଥାଟା ସେ କହୁଥିଲେ section 31 ରେ ଗୋଟେ ଅଛି.
I told you that.
How introduction of a partner.
ଆପଣ you cannot because it is by contract. So a legal heir of a partner cannot claim to be a partner.
Yes.
Which you cannot.
And when all the remaining partners give consent, then go on.
So it has to be a contract.
Section 31 of
that point is so anyway.
That your lordship may take note of.
Again?
Your lordship may these are my submissions.
No, correct. No, we have to wait because he's again so just wait for him. So if you have stood by one, ଆପଣ ଯଦି ଗୋଟାକରେ stick କରିଥାନ୍ତେ. Suppose 24 is a valid argument as far as the legal point is concerned. Notice to agent partner is sufficient. So then let us issue notice to the partner. That notice is not to the partner, to the farm. Now suppose let us assume there is a section 7, that covenant 7, not section 7, covenant 7 authorization that has not surfaced, whether or not there. But your argument is power of attorney is akin to that 7.
Yes, my argument.
But
it is not specifically mentioned in the power of attorney that you will get received notice.
So obviously. So
it is implied.
And that is how I pointed out that language used in just now जोटा मैं देखुथिले आपण जोटा प्लेस करथिले सी भी प्लेस कला आपण तापर प्लेस कले सेटा जो पावर ऑफ अटेंड को पेज रे अछि
सेटा हो कि
7
पावर ऑफ अटेंड पेज 7
मोर ब्रीफ टाको पेज मार्क करना हंते आपण
रिप्लाई टू रीजन
सीरियली नहीं इंडेक्स भी सीरियली
the reply to rejoinder page 7
कौन सेटा ता नाटा कोन
reply to
rejoinder
document ना
document होची power of attorney dated 11/4
होची 7
yes start होची 7
power of attorney
yes
and annexer mark
annexer D/4
नहीं सेटा आपण कहि छथि मु आपण के सेटा मु आई हैव नोटेड बट since it is not page mark I have to again and again note it. Because usually what happens like taxation matters, they say that it cannot be resurrected. But here is a case, you will be given that liberty to do it again. D/4 रे आपण से language ता देखंतु जोटा आपण एबे गले that is page 10
yes
Devendra
Pandya
who is one of the partner of the above named firm as our true and lawful attorney holder of us and on our behalf to do any or all of the following acts and deeds and things. Now suppose if you make it covenant 7 जोटा notice सेटा ता language ही थांदा as it से थांदा और ही थांदा as true and lawful attorney holder of the partnership firm. Interestingly आपणकर एथिरे जोटा power of attorney से 9 जण देइचंती they have said themselves because most likely Mr. Lenka the language is because then the issue of profit sharing and all those things will arise.
Yes.
They have their share of property. They could not have given it to one Devendra.
Yes.
Mr. Palitkar commission has. ଆପଣ କୋଉଟା ଛାଡିଦେଲେ ବୋଲି କହୁଥିଲେ କୋଉଟା ଏଇ ପାର୍ଟଟା
এইটা
ସେଇ ଯୋଉ ଲାଇନ୍
ଆଉ ଗୋଟେ ଖାଲି ସେକ୍ସନ ଗୋଟେ ପାୱାର ଅଫ ଆଟର୍ଣ୍ଣି ଆକ୍ଟ your lordship, if your lordship have the book.
No, power of attorney, Mr. Lenka, why we need to, all three of us need to discuss, because power of attorney is not disputed actually. What is being argued is, or debated is, or we are articulating is contents of power of attorney and its implication.
Yes. Yes, sir.
प्रधान कर लिखिए ना सुलेखा कर कौन लिखिए हो सीनियर काउंसिल कर दिया हो The Lorded Council places the power of attorney placed on record marked as D/4. That is part of reply to rejoinder filed by the state. D/4 ଟା ଦେଖିଲେ ଆପଣ ସେଥିରେ ଅଛି page 73 ହେଲା 7 page 7 ଦୁଇଟା page must be 7 or 7. Power of attorney let know on mail by these presents. Then tinta dot की cross cross 1, 2, 3. But in 1 है Mrs. Pia Pandya, 2 Miss Rasmi Pandya. कर दे बेटा ये जब ये लिखे दरकार Mrs. Pia Pandya tinta dot. Miss Rasmi Pandya tinta dot. You are not the same Rasmi. You are not a partner there. The firm. You are Pradhan. But there is one Rasmi Pandya also. I thought that to defend your case, you have also now done the ropes of the lawyer. Miss Rasmi, then Miss Payal, then Nirmal Kanti, then Bhanumati. 6 Kumari Nita, 7 Tushar Hariprasad Hirji, 8 Nirmal Kumar Hariprasad Hirji, 9 Kumari Gayatri Hariprasad Hirji. Comma, do hereby constitute, nominate and appoint to one dash Sri Devendra Prasad Hirji Pandya. Comma, tinta dot chhad debe. Tinta dot tapare. Comma, who is one of the party public partner of above named firm as our true and lawful attorney holder for us and on our behalf, comma, to do any or all of the following acts, deeds, and things. Things for a colon slash, colon dash, not slash, colon dash, beta into dash. The Lorded Council then takes through the Lorded Senior Council, then places the contents of the said power of attorney dated 11/4/1992.
Well,
2000.
Now therefore
11/4/2012 madam.
11/4/2012.
Yes.
अच्छा अच्छा सेटा देखा जी 9 भलिया
हाँ 9.
2012.
Yes.
At internal pages 5 से पूरा प्लेस कर दो इंटरनल पेज रे सेटा हबो पेज 11 रे अछि 1 to appear before 1 2 3 4 5 6 generally to all acts it is further does hereby declare that is further does hereby declare that ରହିଲା up to page 15 it is submitted by the London Senior Counsel that none of the above covenants as indicated and contained in the power of attorney would indicate that the parties, the 9 persons giving power of attorney had waived their right to receive notice or it can be interpreted that the necessity of giving notice can be bypassed. Necessity of giving notice to all the 9 individuals who are partners in the firm, who are lessees, who are lessees and are partners in the firm. Sentence after putting last. Can be bypassed. He submitted that the power of attorney holder was never authorized, was never given the power to receive notice on behalf of the partnership firm or the individual lessees, including him, that formed the partnership firm. DGA को सबमिशन लिखो apart 3 and 6 chhoda Mr. Lenka, you are relying on all. The Lord DGA relies on the covenant contained in the said part of attorney, which has quoted above. To argue that the Devendra Swansu Pandya is authorized to receive notice on behalf of all. काली का उत्तर रखियो ना मिस्टर पालित कौन कहते
That's
कल पढ़ेगा.
So hearing concluded. Okay, because I have a difficulty. My assignment is next assignment is at 4:30. So I have to rise.
And nothing left.
Nothing left.
Nothing.
I think you have done the good work also. You should be encouraged.
Ultimately, the result matter will
Because I have made it open so that even if you argue, you should not feel disappointed that what will be the result.
Pardon, Your Honor.
Yes, please.
Item 12, I was not there at the time. Kindly, he positively will file the affidavit on Friday and in presence he will come. So that order may be recalled.
No.
But he will present on Friday. Because I am instructed by Mrs. Rupla because he's someone died in his family. He could not come. So he has instructed me and because of my, if this thing happened.
Everything we are so transparent. Your presence or not presence at 2, your appearance at beginning of the day's proceeding, now everything is visible.
Yes.
So those days are gone.
Those
days are gone when we can think that we are not noticed or recorded. So obviously, whatever has there is nothing against. Only the facts are noted.
In Friday,
because rather perhaps you could not understand. Regarding the operative portion, Mr. Lenka.
Yes.
Sit up. What gala? से जो सेते 6 मासटा को आपनकर एबे से रिमांड हेले आपण केबे अपियर करबे गोटे कोन से कुछ 1.5 मास जैसे रहिबे दैट इज डिफिकल्ट so since he requests and he will be absent and personal difficulty and during summer vacation after summer vacation केबे रहि परिबे गोटे डेट मिस सुप्रेखा आपण सेटा आई एम सॉरी अरुणिमा I'm sorry, Ananya. Upon said date that can appear Koribe. I think Mr. Lenka to inform your senior.
After vacation.
After vacation upon date, but give a definite date.
Sometime in July.
ठीक है जुलाई appear करिवे pleadings complete करिवे कितने दिन रे extension मागिवे तो सेवन से अधिक नहीं होतो किंतु extension मागतो most likely I have not interfere in extending the matter माने period not matter 6 weeks ठीक है तापर आपनकर 6 पर आपनकर 4 आपनकर भी 6 weeks आपनकर जहाँ भी pleadings complete करियार थिबो reply दबार थिबो अच्छा ठीक अछि आपण जुलाई रे appear कले जुलाई धरंतु
जुलाई मिड जुलाई
तो ठीक है तो कोई पर्सनल डिफिकल्टी को जुलाई 15
काली सर आसले
yes so your submissions I have noted that you are relying on that power of attorney and
extremely hectic today.
Notice contemplates does not contemplate that here so you are relying on associate good line advocate the senior advocate relies on the covenant at paragraph 7 of the lease deed indicating notice.
I'm not here in July माने
आपनकर नोटिस केबे हबो कोन आपनकर एब्सेंस नोटिस ले किछ असुविधा अछि
जुलाई रे हो मुटी आसी माने पुनी रिप्लाई रहयो
नहीं से ताकू नोटिस दे अपॉर्चुनिटी दिया ना तो नोटिस रे आपण केबे नोटिस से इशू करि परिबे अपियर करिए नोटिस अपियर करिवे नोटिस आउटर इशू हबो to all the affected parties
mid July
mid July
जुलाई 15 रु ना जुलाई 6 रु ना केते
mid July रे पट mid July 15
नहीं why I say that आपण पछे नोटिस ता जल्दी नियंतु किंतु so that you get more time
for reply
6 जुलाई हबो
6 जुलाई appear करिवे
हां ठीक है 6 जुलाई रे नोटिस जाओ and those who are already on record ए जे एथर के जण 4 2 6 7 जण अछन 7 जण 6 जण सेठी आपण अपियर करिवे आई विल बी डायरेक्टिंग यू टू अपियर नो फर्दर नोटिस ठीक है एनी अदर नोटिस जुलाई 6 हैला
आ चाइल
ये भी आपण जाउ डाकिवे आपण अपियर करले एनी फर्दर नोटिस दे विल इशू नोटिस giving them time to file their reply,
To the
and
show
all
cause.
your reply within 6 weeks.
To the show cause.
ଆପଣ ଆଉ କଣ ଚାହୁଁଛନ୍ତି ସେଠି appear ଜୁଲାଇ 6 ରେ you require any more documents? ଯଦି
ଆମେ-
ଚାହୁଁଛନ୍ତି make an application, get it from the authority.
That deal also may specify.
I'll
In July 6 ଆମେ
appear କରିକି ଯାହା ମାଗିବା କଥା ମାଗିବେ,
ସେ ଆଗରୁ ଆମେ
ଦେବେ,
release-
ଦେଲା ପରେ ଆପଣ 6 ସପ୍ତାହ ନେବେ। ଆପଣଙ୍କ ଆପଣ ଯୋଉ 6 ଜଣ ସେଠି ଯାଇକି appear କରିବେ।
ତାହେଲେ ଜୁଲାଇ 10 କରିଦେବେ।
ଠିକ ଅଛି 10 ଠିକ ଅଛି।
ଜୁଲାଇ 10 କରିଦେବେ ମୁଁ ଟିକେ
Because second part is important.
ଆଜ୍ଞା
Second part important ଯୋଉଟା ଆପଣ କଲେ। So ଆପଣ 10 ରେ appear କଲେ ସେ ଆପଣ ଯାହା this appearance will be before the certificate officer or the mining officer.
mining officer demand issuing authority is mining officer. Mining officer issue କରିଥିଲେ
I think mining officer it's
mining officer
because certificate officer କଣ ଦେଇପାରିବ ତ କିଛି ନାହିଁ।
he can't issue notice
ତାଙ୍କ ପାଖରେ ନାହିଁ ବି କିଛି କାଗଜ।
କିଛି ନାହିଁ mining officer
Deputy director mines DDM.
no mining officer is one rank below
mining officer has submitted
submitted rank ରେ ଥିଲେ
your election.
that's the equivalent
ନାଇଁ ଏଇ notice ଟା କିଏ ଦେଇଛନ୍ତି?
Mining officer has submitted requisition before the certificate officer. Certificate officer has issued notice.
But the problem ହେଲା
no demands
we are now debating whether determination of the individual liability before submitting the certificate has to be done.
Then your election.
So that at least you also get the chance, because then they will take the same plea. ସେଥିରେ annexure ଯୋଉଟା notice ରେ କି notice କରିଛନ୍ତି?
DDM
DDM
annexure F3 F/3 ହଉଛି DDM
ଓ କାଗଜଟା ଦେଲି
2/9/17 DDM
ଠିକ ଅଛି ସେ କାଗଜ ଗୁଡାକ ଦିଅନ୍ତୁ। ମୋର ଯୋଉ ସାଙ୍ଗେ ସାଙ୍ଗେ ବାନ୍ଧି ପକଉଛନ୍ତି ମାନେ
page 78
ଜୁଲାଇ 10 ରେ DDM ଙ୍କ ପାଖରେ appear କଲେ, you will be have opportunity of getting all the records.
on making a proper application
apply କରିବେ। ଆପଣ 2 weeks ନା 3 weeks ରେ ଦେବେ?
ଆମେ
ସେ ଆପଣ ଯାହା କାଗଜ ମାଗିବେ ଆପଣ ଦେଇଦେବେ।
subject to availability no?
ସେଟା ଠିକ। Obviously you will have that, it is not available. ସେଥିରେ କଣ
3 weeks
ସେ ଯାହା ମାଗିବେ ତା ଦେବେ ତ ତଥାସ୍ଥ ହେଇଯିବ।
all the documents are having with
No, ସେଇଟା ଶୁଣନ୍ତୁ this time this will be with a proper dimension. ତାଙ୍କ ପାଖରେ ପ୍ଲିଆ ରହିବନି ଆମ ପାଖରେ କାଗଜ ନଥିଲା।
ଆମର ଏଠି ଖାଲି ନୋଟିସ ଦିଆ ହେଇନଥିଲା, ଏଇ ନୋଟିସ ଟାକୁ ତାଙ୍କ ନାଁ ଚେଞ୍ଜ କରିକି ତ ଦବୁ ଆଉ ସେଠି ଡକ୍ୟୁମେଣ୍ଟ ଦରକାର କଲେକ୍ଟର ପାଖରେ
ନା DDM ଙ୍କ ପାଖରେ ଦରକାର ଆକ୍ଚୁଆଲି। ଆପଣଙ୍କର DDM କୁ ଯୋଉ ନୋଟିସ ଅଛି ସେଥିରେ ଯଦି ସେ କିଏ ଚାହିଁବେ କାହିଁକିନା ସେମାନେ they will because certificate is a recovery like of surfacing.
relevant document your lordship may say the relevant
obviously relevant
ସେ କୋଉଠି କଣ ମାଗିବେ
ଆପଣ ସେଥିରେ ଡରନ୍ତୁନି।
department
ଲେଖା ସେଥିରେ ଡରନ୍ତୁନି, ରାଜର ସେଇଟା ଆପଣ ଖୁସି ହେବା କଥା ଯେ ସେ ଚାନ୍ସ ଆପଣଙ୍କୁ ଏବେଠୁ ଦେଇ ଦିଆଗଲା।
your lordship might have gone through many cases in disciplinary proceeding. Some they are asking for documents which is not available in the
ସେଇଟା ଆଜ୍ଞା ସେଇଟା ତ ସେଥିପାଇଁ ସୁପ୍ରିମ କୋର୍ଟ କହିଲେ ଆକ୍ଚୁଆଲ ପ୍ରିଜୁଡିସ୍ ହବା ଦରକାର। ଯୋଉ ଡକ୍ୟୁମେଣ୍ଟ ନଦେଲେ ସେ କହିବେ ଯେ ଆପଣଙ୍କର ଜାତକଟା ଦିଅନ୍ତୁ।
since 1993 that law has been laid down even before that even before 93 that law is there
they will be doing that at their own peril. ସେ କହିବେ ଯେ ଆପଣଙ୍କର ଜାତକ ଦିଅନ୍ତୁ, ସେଥିରେ କେମିତି ହବ?
ଆମକୁ 6 weeks
ଆପଣଙ୍କୁ 6 weeks ଅଛି। ଆଚ୍ଛା ଠିକ ଅଛି, ଜୁଲାଇ 10 ରୁ ତାହେଲେ 6 weeks ଆପଣ ଦେଇଦେବେ। ଠିକ ଅଛି, ତାପରେ ଆପଣ ରିପ୍ଲାଏ ଦିଅନ୍ତୁ 6 weeks। ତାପରେ ପ୍ରିଡିଂସ୍ କମ୍ପ୍ଲିଟ୍ ହବ 4 week। after you exchange the first pleadings reply ପରେ सिक्स वीक्स वाला रिप्लाई ये जो 6 weeks ପରେ 10 ପରେ 6 ତାପରେ 6 weeks ତାପରେ ଆପଣଙ୍କର exchange of pleadings ହେଇଗଲା and pleading completed within 6 week ପରେ ଧରନ୍ତୁ ଆପଣ ଦେଲେ ସେ ଚାହିଁବେ ତାଙ୍କ ରିଜଏଣ୍ଡର ଦେବେ ବୋଲି ଆପଣଙ୍କର ଯୋଉ ଆପଣ ଯୋଉଟା ବର୍ତ୍ତମାନ ଆପଣ କାଉଣ୍ଟର ଫାଇଲ ଅବଜେକ୍ସନ ଫାଇଲ କରି ରିଟନ୍ ଷ୍ଟେଟମେଣ୍ଟ so since it is documentary so they may file something that time should be given to them
Under 4 weeks,
4 weeks
4 or 5 weeks could be.
ଏଥିରେ ଆମର ତ DDM ଏଠି ଯେହେତୁ DDM ପାଖରେ ଅଛି DDM
Actually, mining officer, sir, actually mining officer should have issued the notice.
mining officer has issued notice, yeah.
No, no.
But in the name of the
वो appropriate authority କରିଦେବି ଠିକ ଅଛି what he is saying that technically mining officer is the authority in the act ଠିକ ଅଛି but ସେଟା ଆପଣ ଯଦି notification ନେଇକି DDM କୁ power ଦିଆ ହେଇଥିବ
ସେଟା ମୁଁ ଜାଣିନି sir, I have not.
ହଁ ତେଣୁ ସେଇଟା but appropriate authority ମୁଁ କରିଦେବି ହେଲା ସେ appear କରିବେ DDM ଙ୍କ ପାଖରେ appropriate authority shall issue notice ଠିକ
How will
prepare
appear
ହେଇଗଲା।
before the DDM? Appropriate authority
appropriate authority
shall issue notice.
ତାମାନେ 6/6/4 ରେ ଆପଣଙ୍କ pleadings complete both of you agree
ଆଚ୍ଛା
ତାପରେ opportunity of hearing personal hearing ହେଲେ କି to advocate ହେଲେ how much time
August
ଏଠି ହେଲାନି କି 6/6/12 16 week 16 week ହେଇଗଲା ମାନେ 4 ମାସ ହେଇଗଲା
ତାପରେ ଆଉ ଗୋଟେ 1.5 ମାସ ଖଣ୍ଡେ ଦିଅନ୍ତୁ
ତାହେଲେ
ତାପରେ ପୁଣି କଲେକ୍ଟର ପ୍ରୋସିଡିଂ ଅଛି
ନା ସେଟା ଆପଣ ରିଜେକ୍ଟ କରିଦେବେ ନା ଆପଣ ଯଦି ଆଲାଉ କରିଦେବେ ସେ କଲେକ୍ଟର ଆପଣ କଲେକ୍ଟର ଯିବା ଦରକାର ନାହିଁ ଆପଣ ରିଜେକ୍ଟ କଲେ ସିନା ଆପଣ ଯଦି ତାଙ୍କର ଆଲାଉ କଲେ ସେ ଯଦି ମାନିଗଲେ ପଇସା ଦେଇଦେଲେ ଆପଣଙ୍କର କଣ ଅଛି ଅସୁବିଧା
2 ମାସ ଦେଇ ଦିଅନ୍ତୁ
କୋଉଟା
around 2 months opportunity of hearing personal hearing ଚାଲିବ
ନିଅନ୍ତୁନି କଣ ହବ କହିଲେ ଆପଣଙ୍କର 1.5 ମାସ ହେଇଗଲାଣି ଆଉ ଆପଣ ହଁ ଠିକ ଆଉ 6 weeks the hearing will be completed within 6 weeks there
6 weeks
lessee or their authorized repeated
ठीक है lessee or their
authorized
lessee or
for hearing
hearing रे जी participate करिवे
lessee or authorized
Six weeks hearing complete ହେଲା 2 weeks रे judgment 2 weeks authority shall ଯାହା କରିବେ ଆଉ ଠିକ ଅଛି ସେଟା ତାଙ୍କ ପାଇଁ ଟାଇମଲାଇନ ଫିକ୍ସ ରେ କଣ
ସେଟା open ended
their prerogative right
a lot of administrative duties ରହୁଛି ତାକୁ ସେ କହିଥାନ୍ତି transfer posting ବି ରହୁଛି ଅସୁବିଧା
କୋର୍ଟକୁ ତ 20 ଦିନ ଅପସନ୍ କୋର୍ଟକୁ the officers are coming 15 to 20 days ଏ DDM ଫିଡିଏମ ସବୁ କୋର୍ଟକୁ ତ ପ୍ରାୟ almost every day
ଆପଣଙ୍କର ଭୁବନେଶ୍ୱରରେ ଯୋଉ ଅଛନ୍ତି ସେ କହନ୍ତି ସେ ରହୁଛନ୍ତି କୋର୍ଟରେ that is the news in the sub collector and tahsildar they stay in high court in my days that was the comment on that
your lordship strength badly needs to be augmented the numbers on the other side badly needs augmentation grateful
yes
too many cases piling up actually